here today at the autumn edition of the Mitchell-McLean trial competition. We're very happy to see you here. And first we'll start with the introductory speeches, and I would like to invite Fernanda Pastor, the Vice Dean of the Law School. Yes.
Does this work? Yeah. So thank you, Maxime. Thank you everybody for being here. It's great to be able to say a few words here before the start of today's event. There's a lot of people I want to thank, and I don't want to miss anybody because I've been asked by the Dean of the Law School, Soledad Atienza, to be here and to do so I'll try to do my best, otherwise my colleague Antonios will make fun of me. So first of all, of course, I want to thank our hosts, Perez Llorca. I understand this is the 4th edition of this competition. It's actually the 4th time in a row in which they host the final round of the competition. So thank you so much to Perez Llorca. I have to say that this is yet another example of the fruitful collaboration that our two institutions maintain. I invite all of you actually to have a look at the IE Perez Llorca Chair of Commercial Law, which is a research center funded by Perez Llorca but located within our law school, through which we'll do plenty of activities, in some of which Antonios and myself are actually involved. I also want to thank, of course, everybody who makes this competition possible, starting with all ELSA members, and in particular with its president, Jade, its Secretary General, Maxime, and Martina and Katerina, who play a very significant role in the organization of this competition. We really value all the work that you do. I want to thank all our faculty, all the professors who have participated in the previous round, and of course especially the two professors who are here with us today, Professor Antonios Korotakis and Victor Simancas. Again, thank you for your generosity in collaborating in this activity, which would not be possible either, of course, without our wonderful undergraduate management team, and in particular without our associate directors, Eliza, who's here, and Victoria is not here, but Eliza will say a few words after me. I want to finish by saying that this competition has really become one of the flagship projects of our school, and I think it has become so because it encapsulates so well the identity and the philosophy of IE Law School, right? We are a law school that is very much sort of invested, as you know, in the idea of global law, right? In the idea that law should not be taught within the narrow borders of a single jurisdiction, but rather with a very strong international, European, and comparative component, which is why we've been pioneering since 2009 through our Bachelor of Laws sort of global law programs. We also do so, of course, in our master programs, where we train lawyers for international legal practice, and through our corporate and executive programs, where we really train global leaders across all sectors, countries, and continents. So again, this global law focus is really very much in line with the identity of our school. Our school is also very committed to experiential learning, right? To the idea of teaching and learning by doing, to the idea that the best way of actually getting a solid legal education is by really sort of doing hands-on work. We do so, as you know, through simulations, role plays, a very heavy focus on the case method, and of course through moot courts and trial competitions such as this one. And finally, I also want to say that we are a law school whose sister institution is IE Business School, in whose DNA, the idea of entrepreneurship, is very important. And I think this is also a wonderful example of that, insofar as it is a student-led initiative through ELSA. And again, we are very proud to be able to help you guys with it. So again, thank you to Perez Llorca, thank you to the organizers, to the team, and to our professors for making this possible. I hope you enjoy the rest of the evening.
Thank you so much, Maxim. So as both Maxim and Fernando said, I would love to give you a really warm welcome to the autumn edition of this Mitchell-McLean Moot Court competition. It's a real pleasure to be asked to say a few words here, so thank you very much. I'd also like to start by thanking Perez Llorca, as Fernando did. You are also very lucky that Perez Llorca provide you with the platform to showcase your talents and to immerse yourselves in the legal world. So thank you very much for this opportunity. I also want to express my appreciation for ELSA IE, of course. A few years ago, Dane Chilton and Jorge San Juan stopped by my office at the Tower with the idea of creating an ELSA IE chapter. and their idea has evolved into those of you who are sitting here today. I often discuss with my colleagues at law school and in other departments and campus life and across the university how much of an absolute pleasure it is to work with such fantastic students. You consistently wow us with the amazing events that you organize. I'm really not sure how you fit it all in. If you could share any tips with me, I would greatly appreciate it. You're an absolutely outstanding community of students, and your creativity, your hard work, and your passion for what you do never ceases to amaze me and all of my colleagues. So congratulations on that. Today's a testament to your brilliance, so I commend you for all of your efforts. I would also like to take a moment to thank our professors, your mentors, my team, the undergraduate team at law school. Their time, expertise, and guidance really doesn't go unnoticed, and they're really paramount to the success of all of you. So thank you to all of you as well. Fernando did talk a little bit about how important these activities are, and it's really true. They really play an essential role in your training as legal professionals, in your development. It's giving you the chance to really refine skills that are going to set you apart in the legal world beyond your studies, okay? So really take advantage of this opportunity, and I hope that you enjoy the afternoon, the trial this afternoon. Finally, last but not least, congratulations to Jade and Maxim, our case writers and part of the judging panel here. You're an absolute joy to work with. I'm so proud of the passion that you have for ELSA, of the passion that you have for IE Law School. Yeah, it's really fantastic. And thank you also to Catherine and Martina, who were also really important to making this event happen today. So to all of the participants, regardless of the outcome, you will leave this room with skills that will be long-lasting, and they'll last your lifetime. So take pride in everything that you've done to get here and enjoy every moment. Good luck.
Thank you. I first off want to say thank you to absolutely everybody, and I feel like Eliza and Fernando have definitely encapsulated the things that we have for the law school, for Perez Llorca for hosting us and for participating here today, for our professors for being with us and dedicating and devoting your time to this, and to the students, because you guys have put in so much work, and I have seen that happen throughout the last few months, and I have been so grateful and so honored to see you all grow from the person that you were 2 months ago when I met you, because some of you are first years, some of you are second years, and I didn't know you, but I have seen you grow, and it has been such a pleasure to see that. And I hope that this competition has been able to show you that and help you to a certain degree in your law school journey. As president of ELSA IE and as secretary general of ELSA Spain, it is an absolute joy to have this as one of our flagship events here at IE Law School. And as ELSA IE, we are one of the most active associations or chapters here in Spain and quite frankly across ELSA International. And it is so rewarding to see all of our students be so engaged with these activities and to consistently show up and just prove how much IE Law School has provided for us and how much we as a community strive to do better and to provide a better tomorrow for our world. As was previously mentioned, one of the bigger parts of this competition was our founder, Dane Chilton, and on his behalf, I will be doing a little story time for you guys today. So, some of you are, I'm sure, aware of the backstory to the Mitchell L. McLean trial competition, but for those of you who don't know, I'm going to give you the very shortened version of it. Dane Chilton was our founding president, and he was very much in awe with wanting to do law as a career. And if you guys know Dane at all, he is a character, and he is someone so strong and such a remarkable person to be around. And imagine that in a little person form, a child. And he had that dream of being a judge. And his wish was to be able to shadow one and see how that experience was like first person. And he had that opportunity with Judge McLean. And so when he was little, he was able to shadow and be in those court proceedings with him. And it really cemented for him that idea and that dream to be able to contribute to the legal system in some shape or form. Unfortunately, Judge McLean did pass away, saving the life of somebody else while they were drowning. He unfortunately did save the person, but unfortunately did lose his own life in the process. And to this day, we do honor his legacy with the Mitchell L. McLean Trial Competition in upholding justice and serving civil society for a better future. And I hope that those values and that legacy is something that can live within you and within our organization as we move forward. And under my presidency, I do try to live through and live by those ideals that we have set with Dane in the past. And I'm very excited to see how you guys perform today. And I want to say I'm very, very proud of every single one of you here. And you guys are all going to do phenomenally. And I absolutely believe in you all. And you guys are I'm just very, very proud. There's no better words than that. And so with that, I look forward to this. And I hope you guys enjoy the 4th edition of the Mitchell L. McLean Trial Competition. And I'll hand it back to Maxime. Do I get to introduce you? Okay. Now we have our wonderful Secretary General, who will be closing out the speeches for today. And he will be the presiding judge for this competition. And I do want to give him a special thanks, because without him, this would not have been possible, because I saw how many emails you guys all sent him within the last few months. I have personally been CC'd on all of them. So my inbox, my poor inbox, has been filled by them. And this would not have been possible without him. So thank you, Maxime.
Thank you, Jade. And good afternoon to everyone. As Jade said, that I'm very honored to be here in the position of Secretary General of ELSA IE, and as well as the Editor-in-Chief of the ELSA IE Law Review and the presiding judge for the purposes of the Mitchell L. McLean trial. So I want to tell a brief story. My first interaction ever and introduction to ELSA IE and the ELSA organization in general has been the participation in this mock trial. Throughout the years, I managed to participate in the first ever edition and then the second edition, and I have helped out throughout the third edition, which has been happening last semester in the spring, and I have the honor to continue the fourth edition and now be here in the role of the presiding judge and sit across on a different side of the bench. Throughout the experience, I have managed to learn the variety of different skills, from professionalism, oral argumentation, writing briefs, and teamwork, which is happening a lot when you're trying to come up with a strategy for the trial. And I hope that with our leadership, we have managed to do the same for you and to give you this opportunity to develop those skills better and to help you in the professional life when you go along. I also want to mention that this edition has been a very rigorous process, and we have started from 100 individuals competing and being in the roles of jurors, in the roles for the body round, as in the roles of witnesses, and of course the teams in the roles of counsels. And now we're here today to to test the skills of the 4 amazing teams that have come to the final. So with that, I think that we should start today's edition, and I would ask quickly to introduce every judge, and if you could say a couple of words about yourself so the participants can know you. Thank you.
I'll be very quick because I guess all of you are eager to start. So my name is Victor Martinez Simancas. I am a business and corporate law professor at IE Law School. I'm also a practicing lawyer. I've practiced corporate law for several years at a law firm, and then after an American experience, when I returned back to Spain, I moved to be an in-house counsel. And where I've been there for 3 years already, and this is my second year at IE Law School, which I love it. I participated in the previous oral argument that we had, which I enjoyed a lot. The students who participated there that I see most of you here today were amazing, so Looking forward to start as soon as possible, and thank you for inviting me again.
Hello, my name is Antonios Kouroutakis. I'm a professor at IE University. It is a pleasure being here. I'm doing my best to be supportive to the ELSA initiatives. The reason is that when I was a student, I was also one of the founding members and, member of ELSA in my university. It was one of the two defining experience in my academic life as an undergraduate student. So I do urge you to participate as much as you can in these extra curriculum activities. At the end of the day, these activities, this experience, are experience that you will remember after years, and probably they will define you. So let's move on.
Thank you, Antonios.
Yeah, my name is Alessandro Mazza. I'm currently doing I'm a legal practitioner, basically, doing here at Perez Llorca in competition law. I'm also an IE alumni. Last year I finished my master's in legal practice and corporate law, and yeah, it's a great opportunity to be here, to listen to everyone, and yeah, I wish you all luck.
Hello, everybody. I'm Cristina. Just like Alessandro here, I am a IE alumni from last year. I did my master's at IE. I am a soon-to-be, practicing lawyer, I'm trying, in white-collar crime and investigations here in Perez Llorca. And so thank you all very much for all the hard work you put into this, and I'm looking forward to hearing you all. Good luck to everybody.
Thank you very much. And with this, I think that we should start. I want to ask Martina and Catherine to take the second round groups to their rooms. And after that, we will start the round. I would like to ask the petitioner whether you would like to reserve 5 minutes for the rebuttal argument.
Yes, Your Honor.
Yes, okay. So you will have 25 minutes, okay? We're now here in the Supreme Court of the United States, and the case in front of us is Institute for Free Speech and First Amendment Coalition as a petitioner versus United States of America as the respondent. And with that, I would like to ask whether or not the petitioner is ready to start their oral argument.
Yes, Your Honor.
You may come to the podium and start.
May it please the court. Your Honor, today I have brought a weapon to court. A weapon that can cause anyone, anywhere to riot. A weapon that can kill politicians, societies, and civilians. But Your Honor, I alone did not bring this weapon today. My co-counsel possesses this weapon too. You yourself possess this weapon. This weapon, Your Honor, is granted to us by the First Amendment, the freedom of speech. Now, the reasonable person would never consider our freedom of speech to be a weapon. But this is the picture that the respondents will paint today. They will convince you that our freedoms granted by the First Amendment are just as dangerous as weaponry and require intervention by the government. Specifically, the US Congress passes the Media Integrity and Security Act, a bill that does two things. One, it restricts average citizens from publishing online content and exercising their First Amendment right. And subsequently, two, it has transferred the modern understanding of social media as a public forum to a publication. Now, Your Honor, don't let the respondents confuse you. This is not a simple restriction on the use of social media. This is the first step in complete government arbitration over our rights. The US Congress uses the guise of safety to arbitrate our rights, but they are systematically removing a source of communication and a platform of government criticism and discourse. The petitioner finds three main issues regarding the bill. First, the obvious. I will argue that the bill violates the First Amendment. Second, my co-counsel, Ms. Ramos, will argue that the MISA bill violates the Equal Protections Clause of the 14th Amendment by creating a subgroup of individuals that can express their rights differently and are treated differently under the legal system. And finally, my co-counsel, Ms. Darras, will deliver the final argument that the MSA contains provisions that trigger the vagueness doctrine.
Excuse me, Counselor, before we start and we go to the substance of the case, can you please assist the court with your standing? In particular, can anybody bring a claim against the unconstitutionality of this law? What is your standing? What is your particular interest? Do you have an injury?
Your Honor, yes. The petitioner finds that the two components of this case, the First Amendment Coalition and the Institute for Free Speech, find that this bill is absolutely overbroad and does violate the rights of individuals, as they are not allowed to participate in social media uploading content.
So may I ask you, let's assume that, so we have some citizens and they have a free speech club in Minnesota. Can they bring a challenge to this law?
Yes, Your Honor. The 14th Amendment provides that the United States, any state in the United States, they can bring this bill in a violation against the First Amendment all the way up to the Supreme Court, and that is what we are exercising today.
And may I ask you, I have another question. Can you please assist the court with the legal basis of the MISA for Congress? Based on which basis Congress legislated MISA? Do they have the authority to legislate MISA?
No, Your Honor, they do not have the authority to legislate MISA as it is a violation against the First Amendment.
No, my question is different with a sense. My question is, does the federal government has the power to regulate social media, or the state governments, they have the power to regulate social media?
Well, we see in, after I start my argument on the First Amendment, we do see that there is precedence that the United States federal government is allowed in specific cases to limit free speech, but they are very, very specific, as well as the states, they are allowed to limit free speech in very, very specific situations. However, this bill is a federal bill, so it applies to all 50 states.
Counsel, if I believe the justice is asking you the question of whether the federal, so the Congress, the federal body, has the ability to legislate on this particular matter, or that would be the matter for the states to regulate, so each individual state. And I also wanted to ask you, could you please speak into the microphone?
Oh, of course. Your Honor, the federal government or the state government, they can choose to regulate this specific topic, but regardless, this would be against the First Amendment right granted to all citizens of the U.S., not just citizens of specific states. With this, Your Honor, the First Amendment rights of American citizens are rights that are expected to be protected by the state and federal governments. Individuals expect these rights to be unchecked and additionally well protected by the Supreme Court of the United States. For the MISA creates a prior restraint on publication that has historically been proven as unconstitutional in this court, like in the case of Near v. Minnesota. And in this case, the Supreme Court deemed that a prior constraint or gag on publication is unconstitutional. They deemed laws that outlaw publication on the assumption that it may create harm is unconstitutional, and the speech must be allowed and sanctioned after the fact.
Counsel, may I ask a question here? You're citing Near versus Minnesota. In this case, there are limited circumstances in which prior restraint is not applicable, national security being one of them. Under MISA, they're saying that the application of this law is due to national security reasons. How would you say that prior restraint is applicable in this case then?
Well, Your Honor, when we look at specific cases in which the Near me Minnesota was used to allow the government to arbitrate over free speech, we see it is in cases that are inciting grave danger to all of the United States, as well as that may incite harm or rioting. But in this case, we don't see that. We see a preemptive blocking of the publication and creation of material. There would have to be a very specific person or individual that this bill is targeting. It's just targeting all of the citizens of the United States.
Two things to your point. One, based on the case facts, they are saying that there was circumstances that were happening in the United States at the time that caused Congress to act and thus implement MISA, correct?
Yes, Your Honor.
So under my assumption, then those are the circumstances that we're talking about that would deem a national security threat, whether in your case you're saying riots and violence. Were those described in the case facts?
Well, Your Honor, they were described in the case facts. However, if the MISA wanted to limit situations that would cause speech that would cause harm and rioting, then they could have created a more specific bill, and that is something that my co-counsel will argue very shortly, that the bill should be more specific in its sanctioning of the speech. It should not be limiting and creating a subgroup of individuals over all American citizens, rather just putting a limit on a specific part of speech.
Excuse me, Councillor.
Yes, Your Honor.
Can Congress regulate and legislate that minors, they are not allowed to join social media?
They are allowed to. This would be in the bounds of the specific company, as they would authorize who and who cannot join the specific media.
So the Congress would then not be able to legislate on the specific matter. It would be in the hands of the private company. Is that what you're arguing?
No, Your Honor, I'm not arguing on minors, specifically minors on social media. It would have to be if minors are allowed on social media on the specific platform, and if they are, then they would be subject to the same rights. But this hasn't been a fact that's been mentioned in our case.
No, I'm trying to understand what is the permissible scope of regulation. So may I ask you, can Congress legislate and make specific provision not allowing, for instance, bots to make publications on social media? I'm asking these questions because I want to understand the permissible scope of limitations that you believe that we should accept, or we should leave it open and everybody can post anything, even bots, even aliens.
Well, Your Honor, when we look at what the MISA bill does, it creates it treats social media like a publishing platform rather than a public forum, which it has historically been treated like. So under this, I am arguing that all citizens of the United States should be allowed to use social media, as is their First Amendment right.
My question is then, the First Amendment right is protecting the free speech, and here I would argue that the act does not deny the speech to the citizens. It only denies the platform and the audience. So in my understanding, the First Amendment does not give the person the right to the audience. They are given the right to express what they think and their thoughts, therefore the freedom of speech. So I'm trying to understand the reasons as to why you brought it under the freedom of speech, and how do you define the scope of the First Amendment?
Well, Your Honor, we see the First Amendment, in past cases, we've seen the First Amendment is used not only for publications, but also individual speech. And in this case, the individual speech is being limited, and therefore it is the belief of the petitioner that the First Amendment should be applied because the scope of the First Amendment is very large.
But again, the content of the speech is not regulated by MISA. The only thing that is regulated is the ability of citizens who are not journalists to go and create content on social media, therefore not giving them the platform to express or to broadcast their speech to a wide range of people. They're still allowed to go outside and make a protest or make a gathering, and the content and the speech itself is not regulated within the act. So,
well, Your Honor, this would bring up another issue that my co-counsel will argue, is that this creates a subgroup of individuals, which again is also unconstitutional. Specifically, if we see to the case of Lovell v. the City of Griffin, that this case, the court ruled that no party shall need a government approval before publishing, as it infringes on the First Amendment right. So if we look at that case and we see that social media is being treated as a publication, there is a block. An individual will have to go to a ministry, get approval, and then be able to post on social media. So Lovell v. City of Griffin does affirm the fact that the First Amendment should be applied here.
you can continue with the argument, and you're currently at 11 minutes.
Thank you, Your Honor. Now, if we look to the case of Brandenburg v. Ohio, specifically this case states that speech can be limited when it's likely to incite or produce imminent lawless action. But this argument, as the respondents will argue, is a weak argument, as the bill chooses to restrict publication and therefore treating social media sites as publishers rather than forums of individuals. And therefore, Brandenburg v. Ohio is not a viable defense against the restriction of publication under the MISA. Historically, this court has always sided with personal rights over government intervention, freedom of speech over national security. And Your Honor, if you uphold the appellate court's decision, you will set a life-altering precedent that will undermine all of the past cases brought to you here today. You will be choosing national security over our rights, the first time in history. You will be establishing the first step in total government arbitration. At this time, Your Honor, my co-counsel will now take the podium.
Thank you, counsel.
Your Honors, the Media Integrity and Security Act directly violates the Equal Protection Clause of the 14th Amendment, which is meant to ensure that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. However, MISA creates a two-tier system restricting the First Amendment rights of American citizens, while granting the power to exercise their right to freedom of speech to only a select few. Under MISA, only accredited journalists can freely express themselves, relegating the rest of the public to a lesser tier with limited speech rights. In the case of Police Department of Chicago versus Mosley, this court ruled that the government cannot regulate speech based on identity nor content. Media integrity and
Counsel,
security.
I will interrupt you here. My question is, how do you tie the identity of the person to their professional affiliation as a journalist?
In this case, we're looking at the violation of the 14th Amendment and the Equal Protections Clause, in which the government is allowing there to be a separation of peoples in which journalists and non-journalists don't have the right to exercise their First Amendment right of freedom of speech.
But 14th Amendment is protecting people on their identity and anything that is an unalienable characteristic to their personality. But the work of a journalist is not something that is connected to the identity of the person. Therefore, I'm trying to understand, how are you tying it into the application of the 14th Amendment?
I understand. The 14th Amendment, the Equal Protections Clause, is meant to protect the rights of all citizens equally and the right to exercise freedom of speech to all citizens equally. And what the Media Integrity and Security Act is doing is segregating people, non-journalists, from exercising this right.
But then my question is, would you say then that the division between professionals, for example, limiting the ability to practice law only to lawyers, would also be unconstitutional under the 14th Amendment?
I understand, Your Honor, but I wouldn't go as far to use that comparison, as I don't believe it to be synonymous. Freedom of speech is something that we have all had access to. We all use social media, and we're not all lawyers. We're not all able to access law. These are things we have to study. Social media is seen as a public forum in which citizens of the United States have all been able to access. And right now, MISA wants to restrict this.
Okay, but if I ask you to put aside right now the fact that we're talking about the freedom of speech, I'm trying to understand how, and talk specifically about the 14th Amendment and the fact that it prohibits discrimination on any characteristic that is connected to the identity of the person.
Mm-hmm.
In this particular situation, then, the comparison between the lawyers and only restricting the ability to exercise and argue in front of the court would be something that is connected to their professional affiliation, their knowledge, their education. That is not something that is identity connected, in my opinion.
Mm-hmm.
So I want you to address this particular concern.
Journalists, their job is seen as publishers in publication forums, while people are able to exercise their freedom of speech regardless, anywhere. So it would be can be seen even as identity, considering the accessibility that in a short amount of time, considering that the upcoming elections are growing, considering that even now international journalists have to come in and have to get accreditation from the US to be able to speak on the matters going on, it wouldn't count as constitutional or as identity because it isn't accessible to everyone. So you are stripping the people of their freedom of speech rights because it isn't accessible to everyone.
Councillor, may I ask you, if Congress has legislated a law and has said that we have two different groups, minors and adults, and minors, they are not allowed to publish on social media, would your argument be the same? that there is a violation of 14th Amendment in combination with the First Amendment?
I don't know if I would consider it the same thing as it is now regarding age, which we all age and we all grow, and not all of us are going. I don't see it similarly. I don't see that age would be an affecting category as we're all aging by the second. But to become a journalist, there's a procedure, there's a process. It's a completely different thing.
Counsel, but I'm sorry, exactly age is a part of an identity. And this is a protected, you could say, class, but under the 14th Amendment, it's something that you cannot do anything about yourself. It's just the passage of time. So, in my opinion, age would actually come into the protection of the 14th Amendment, but the professional connection is not.
Yes, Your Honor, I agree. I don't think the professional connection to freedom of speech and to open speech, I don't think it's accurate. I think the professional connection of becoming a journalist is accurate when publishing and wanting to be a verified source, but freedom of speech cannot be limited to only verified sources.
But isn't anyone who is going to social media is actually publishing something?
Yes, but they're not as verified publishers.
Okay, then how would you address individuals who have extremely big amount of followers and who are trusted, but they are not journalists, they don't have education in this particular area, and they're just giving opinions?
They wouldn't have journalistic accreditation. They wouldn't have journalistic accreditation, and they're exercising their free speech, but it doesn't necessarily mean that they're journalists. They're content creators. And this is what's being limited. Content creators, the people that want to discuss publicly the upcoming elections and the government and their opinions. And right now what's going to happen is that if MISA goes through, there's going to be a homogenized discussion worldwide.
I just want to clarify something. So when we talk about this, we say that the 14th Amendment is a protection against discrimination, correct?
The 14th Amendment is the Equal Protections Clause, is that the law applies equally to everyone.
And in theory, in abstract terms, if the MISA framework allows only for accredited journalists to be able to publish on these sites, anyone can then become accredited. Like you said, there is a process. There's a framework there that people can follow to be able to get that accreditation. Thus, it's something that you can change. It's something that you can achieve. That meaning it does not fall under the equal protection because anybody can do it.
Yes, Your Honor, but is that truly accessible? Is it truly expected for people, for teenagers that are just now exercising their vote to right, that are just turning 18, that want to share opinions and hear about the government, to go and now look for an accreditation of a journalist, or for people that are practicing law or business to drop their careers and become accredited journalists simply to exercise their rights to freedom of speech?
But then let's take the example of teenagers that are coming into their first time voting and the first time being exposed to maybe certain topics. If they're the ones immediately publishing or saying something that they maybe don't know the full grasp on, shouldn't we try to protect and try to ensure that the content that we do have out there is something verified and from people that have the education on it and are accredited for it?
Yes, Your Honor, but I don't see it that way. I think that all opinions are meant to be shared, and everyone is meant to then decide and see what they are. It's like you're limiting access. You're limiting access, and you're limiting the information of who is giving the information and what we're able to access.
But the limiting access does not then, it's not mutually exclusive with the idea that then they can't ever do it, because there is a framework for you to do so eventually.
But as I said, it wouldn't be accessible to believe that every single United States citizen will go in and become accredited journalists. Then what is it? If it's all accessible to everyone and everyone is going to go become an accredited journalist, what's the framework for?
Well, then if the framework is based on the fact that they want to make sure that the content being published and being disseminated is not misinformation or disinformation, then wouldn't the uptick of people actually getting accredited and having that knowledge and that accreditation with them be the positive benefit of MISA.
I understand, Your Honor, but I simply don't see it as reasonable to believe that every single United States citizen that would like to exercise their right, their First Amendment rights, freedom of speech, is going to go and become journalists.
Okay.
And may I ask you something else? What would be the level of scrutiny that this court should apply in these cases, violation of 14th Amendment and First Amendment? I mean, should we apply the highest level of scrutiny, strict scrutiny, or should we apply medium level of scrutiny?
I believe that the highest level of scrutiny should be applied, as the United States is a country that works under constitutional supremacy. And right now, the First Amendment right of the American citizens are being violated. Does that answer your question, Your Honor? Okay.
Counsel, you have 2 minutes until 25 minutes are finished.
Now my co-counsel, Ms. Perez, will take the stand.
Thank you.
Your Honours, Media Integrity and Security Act has raised serious constitutional concerns by violating the vagueness doctrine. The vagueness doctrine is a legal principle in the United States constitutional law that requires laws to be clearly defined. Under this doctrine, a law is considered void for vagueness if it is so unclear that people cannot understand what is lawful and unlawful under such law. This doctrine is rooted in the due process clauses of the 5th and the 14th Amendments, aiming to protect individuals from unfair or discriminatory applications of laws.
Counsel, could I interrupt you,
Yeah.
please?
Yes,
Sorry. I would like to ask, which specific provisions are you arguing that are vague under the MISA Act?
Yes. We wanted to the bill specifically states only accredited journalists are those that meet the following requirements. In Part C of this definition, it states that journalists must demonstrate adherence to professional standards of ethics and integrity in journalism. The term ethics is mentioned more than 7 times, and it is a key term in this definition for accredited journalists, although it is never defined. Under the vagueness doctrine states that all laws must be clearly defined, which such an important term, such as ethics, is never defined in the Media Integrity and Security Act.
Counsel, but isn't it a quite usual practice for the Congress to legislate on quite over-encompassing words that can be defined in different ways, and then for the administrative agencies to actually clarify the meaning of those words and create more specific legislation, which is additional to the Act itself?
Yes, Your Honour. However, ethics in journalism can vary widely depending on interpretation, cultural standards, and subjective views. So without these clear guidelines that the Media Integrity Security Act lacks, this requirement leaves too much room for subjective judgment by officials, which can lead to authoritative powers misusing their biases in such cases.
But then my question is, the vagueness doctrine is applicable to a reasonable person, and I would argue that the reasonable person is actually very much equipped to understand that this action that the Act is creating is restricting the creation of content only for accredited journalists. They have the capacity to understand whether or not they're accredited journalists. But the fact that ethics is not defined, this is something that only accredited journalists will need to know. Therefore, it's much higher than the vagueness doctrine.
Your Honour, we would argue that the vagueness doctrine still applies here, as we believe that the definition should be clear on all of its faces. So that would mean A, B, C of the definition for accredited journalists. Thank you.
Counsel, I believe that right now the time has finished for you, and we'll have 5 minutes for you for a rebuttal. Thank you.
Ladies and gentlemen of the jury, in 1997, the first social media site, 6 Degrees, was born. For the 221 years prior to the advent of social media, Americans enjoyed the right of free speech, just as they do today and just as they do under MISA, an act that serves to protect the national security and public safety for all Americans. Today, we will convey to you all that not only does MISA not violate the First Amendment, the 14th Amendment Equal Protection Clause, nor oppose the vagueness doctrine, but it serves a vital role in our democracy. Given the recent assassination attempt of former President Kennedy Jefferson, insurrection, widespread dissatisfaction with democracy, and doubts about election validity, which have all stemmed from misinformation, it has never been more important to limit this unchecked weaponization of speech and dissemination on an exponential scale. Opposing counsel was correct when he said that speech is a weapon. And speech is a weapon when we yell fire in a crowded theater. And it is a weapon when we spread disinformation on the social media, as this is seen on like an immense scale. First, we would like to establish that the opposing counsel and the institutes have no standing. The institutes have suffered no.
Excuse
Yes,
me.
ma'am. Oh, yes, sir.
Before we go to the standing of the petitioner, may I ask you, what is the legal basis for the regulation of MISA?
As social media sites are interstate private companies, Congress has the authority to regulate them under the Interstate Commerce Clause.
Thank you.
Continuing with the standing, the institutes have displayed that they have suffered no significant or redressable harm. Therefore, the court can offer them no redress, and they have no standing. As that has been established, we would like to move on to establishing that the First Amendment has not been violated, and that it is subject to intermediate scrutiny. So, as was established in the case of Ward v. Rock Against Racism, in which city performers in the city of New York were using loudspeakers in the park, and the state decided, that it was appropriate for.
Excuse me.
Yes.
You mentioned that the court applies consistently intermediate scrutiny.
Yes.
For challenges. Can you explain that a bit?
As the MISA Act is regulating solely on the basis of it's not based on content. It's content neutral. It's solely saying who can speak on these platforms. It's subject to a different degree of scrutiny, that is intermediate scrutiny.
So in case we have intermediate scrutiny, what type of interest the government has to show?
It must have a significant or important interest.
So
in the
what
case.
is your important interest to make this legislation?
It is both national security and public safety, as we have seen that there was an attempted assassination on the former president as well.
Is it the first time that there is an attempt for assassination for a president here in the US?
No.
What other measures did we take when we had in the past attempts to assassinate presidents?
I don't believe I know specifically.
Thank you.
Counsel, before you
yes.
continue, government limitations on speech are traditionally presumed unconstitutional unless narrowly tailored for specific or imminent harm. You are limiting here social media broadly. Why do you think this is sufficiently narrowed to be constitutional?
We would argue that under intermediate scrutiny, it's not necessary for the measure to be narrowly tailored. And as this is not discriminating on the basis of content, it's been established in previous cases that these cases in which there is content neutral regulation occurring, they're subject to intermediate scrutiny, which does not require the measures to be narrowly tailored.
Councillor, would you argue that MISA, or I would like to know why you believe that MISA is proportional in the measures that it seeks?
We believe it's proportional in the measures that it seeks simply because it is a matter of national security. It is a matter of our democracy, and it is a matter of the safety of the public. As we have seen, there is a lack of trust, a lack of confidence in the democracy and in the government. We are concerned about the upcoming elections and the integrity of those elections, given the amount of information that is being spread on these social media platforms.
So you mentioned the elections. However, MISA is going to be applicable post-elections. So why this inflection specifically on elections, and is the measure still proportionate after the election period?
I would agree that it is proportionate. However, there's a sunset clause in which Congress can redress or reevaluate the measures annually, as well as it's given a 5-year time limit in which we can reevaluate then. It's currently being put in place, and it is proportional because we are seeing the significant backlash. We are seeing national security threats, and these are things that are very concerning to us as Congress members, and therefore we have decided this is the proper and proportional measure to take.
One more thing, you mentioned threats. However, I believe threats is not the same thing as misinformation. MISA talks about misinformation and disinformation. However, you're talking about threats specifically. I think these are two different concepts. I'd like to know more specifically
Yes.
about disinformation and how that may affect national security.
Your Honor, my apologies. Threats is in response to things that could come of mis or disinformation. They are threats to national security. They are the concerns which we have. Questions?
Before you move on, actually, I do want to mention one thing that you mentioned earlier. You talk about democracy and upholding those values, especially right now during this turbulent time. However, I want you to distinguish where you find the line between upholding those democratic values versus this bill being simply paternalistic.
Your Honor, would you define what you mean by paternalistic?
In the sense that it can come off as not proportionate, overbearing, into a sense that the government is taking what they think to be the best decision without actually consulting the people or taking into consideration that they can choose or decide what is best for them.
Your Honor, I believe that this measure is proportional and is not paternalistic, as we are providing for the national security. And during times when maybe the public disagrees with decisions that the government has made, national security is above all.
But then we come to the idea that the only reason that the government has power, although philosophical, is the social contract. And so if the people cannot give any backlash, if they can't communicate, if there's no way for them to then say that they're not in agreement with something, and through even social media, which is the biggest platform in this day and age, how can we say that it's not paternalistic? And instead it's devalidating or it's hindering democratic values.
I would argue that it's not hindering democratic values, as there have been and there still exist many other platforms and ways for people to distribute their information. They still have the freedom of association, they still have the freedom of speech. You can collect, you can protest, you can write an article in a newspaper. These are all things. Furthermore, you can become an accredited journalist.
May I ask you, so if people, they can use all the alternative ways to communicate their ideas,
yes,
then why does the government regulate social media? Is it going to be an effective law? Because if your concern is and your interest is national security, then our assumption would be that in every form of equivalent speech, the government should step in order to limit that speech. But then it seems that there is a paradox. On the one hand, you argue that there are alternative ways for people to communicate and exercise their rights. However, you decide to burden their speech only in the social media platform. So wouldn't it be more consistent if, for national security purposes, you burden the free speech everywhere?
Your Honor, Congress has established and researched the fact that it is originating from the algorithms which are perpetuating misinformation, as it's often inflammatory. And the scale on which information can be disseminated through social media is much greater.
And then may I ask you, if then the concern is the algorithms, then why you didn't regulate the algorithms and the social media platforms instead of the free speech?
I believe in the MISA Act, it also pertains to the algorithms, and that it wants to promote factual speech.
So then, may I ask whether it was unnecessary to regulate speech and to limit the intervention, the legal intervention, only to algorithms?
I would say that it's not, as it's very difficult for social media platforms and possibly an undue burden for them to have to filter through information to sort out what is true and what is not, and there's very little accountability involved for these speakers. Okay, I yield my time to my co-counsel.
Counsel, you have 20 minutes left.
Okay, thank you. So now I will bring forth regarding the petitioner's claim about the 14th Amendment Equal Protection Clause, and I will be underscoring how this falls and should be evaluated through the rational basis test, specifically given that this test is based on the distinction being a legitimate government interest and a rational relationship between the measure taken and the legitimate government interest. Here, I cannot highlight or emphasize how much the legitimate government interest plays a role. Specifically in this case, MISA comes from a place of there being a really inflammatory, complicated context in which
elections are upcoming. There was an attempt assassination, and it even brings forth the idea of how the pandemic played an inflammatory role with misinformation, creating a lot of chaos in people's lives. So I am arguing that the rational basis requiring a legitimate government interest and rational relationship, that the actions and discrimination, this is done in pursuit of protecting national security and public safety by limiting social media publishing rights to accredited journalists. With MISA, the government's aim is to limit the dissemination of misinformation, and Congress has identified as a critical danger to the country's national security and public trust. For the purpose of...
Excuse me, Councillor,
Yes,
may I
of
ask you, but if the process to get accreditation in order to publish in social media is a simple process, that it's not burdened with red tape, so then what is the intent of this law?
The intent of this law and the focus on the people bearing the burden of getting accredited is specifically to target misinformation. When people go through the process of becoming an accredited journalist, it ensures that you're adhering for a specific ethical and professional standards. You're not just sharing your opinion, you're adhering to a code of ethics.
But then in the First Amendment we have freedom of the press and we have specifically freedom of the speech. Don't you think that if you required every citizen to get an accreditation to become a journalist, somehow we give precedent to the freedom of the press instead of the freedom of the speech?
I do not think so, Your Honor. I believe that we do uphold both principles because there are other channels in which we can continue to exercise our freedom of speech. As my co-counsel mentioned, there are other channels in which we can discuss, and actually the government has set precedent in which this has been allowed, specifically in the case of Greer versus Spock in 1976. A military base found that they could not discuss political matters, and the court upheld that not all government-controlled spaces are public forums, and that the same applies to privately operated social media platforms, can be applied to this. The government can impose reasonable restrictions, and we can continue to discuss our political opinions in other spaces. And just by getting an accredited as a journalist, it allows people to...
But then again, I will make the same question to you. If people can continue spreading misinformation in other platforms, then what is the logic of the law? It seems that the law does not achieve its goal.
I believe that it does achieve its goal because the main core focus of MISA is that algorithms allow for a rapid spread of misinformation. Algorithms allow misinformation to take off extremely quick, whereas we take normal mediums like a conversation between two people, it will take it's a lot less time.
In order to understand what differentiates this present case from the past is the speed of misinformation.
I would argue...
Apart from that, then, if we remove the element of the speed, everything is fine.
I would argue that given that the context in which we live and exist today is that we have social media and the speed of which it has taken off with misinformation and the dissemination of different topics, I think that we cannot exclude that context. And given that the core focus of this law of MISA is to regulate at the speed at which misinformation and disinformation shares, I think that it cannot be separated.
May I ask you, don't you think that it would have been more efficient and more compatible with the First Amendment to impose a burden on the social media platforms to regulate the speech?
No, I disagree. As mentioned previously by my co-counsel, I do not think that it would have been as efficient. If we put this burden on the social media companies, there is no way that there's going to be a way to process all of this information. And not only this, but we're passing on to the companies the burden of deciding what speech to restrict.
But isn't it the right? Don't they have the right to decide who speaks and who doesn't, who is a member in the social media platforms or not?
I would not argue so, specifically given that MISA is a content neutral...
No, my question is, at this moment, Meta, TikTok, don't they have the right to regulate the speech of their users?
They do, but I do not think that it is efficient in the way that they have regulated, so...
Okay, thank you.
Thank you. Now, I want to underscore just the importance of national security and how it really ties into the Equal Protection Clause, and it being that
We are protecting national security. It is the well-being of our nation. To protect our nation, this is why MISA is here. It is not for another reason. Thank you. I yield my time to my co-counsel.
Your Honors, we stand before you today to dispel the appellant's concerns regarding MISA bill and its alleged violation of the vagueness doctrine specifically. While we acknowledge the importance of clarity in our laws, we must also recognize the complex and ever-evolving nature of social media and its impact in our society. The context is essential. Social media's misinformation has led to devastating consequences, as my previous co-counsels have mentioned, to this great state of America. The attempted assassination of President Kennedy Jefferson showcases the growing national security risks associated with escalating tensions. As a result, there are great risks and concerns that have to be addressed. The MISA bill, far from being unconstitutionally vague, provides a necessary and appropriately flexible framework to address these challenges. In Groyard v. City, Rockford, 1972, the court noted that context and purpose matter in evaluating vagueness. First, let's consider the precedent set. In this case, the Supreme Court upheld a city ordinance that restricted noise or diversion near schools. Despite claims of vagueness, the court found that ordinance's clear aim and grounding in legitimate interests rendered it constitutional. Similarly, the MISA bill has a clear purpose and narrowly tailored to regulate and protect users in a rapidly changing landscape of social media. Your Honors, the Media Integrity Security Act includes a crucial safeguard as well. An annual review by Congress to assess its effectiveness and address any unintended consequences.
Excuse me, Councillor, since you are talking about sunset clauses and the annual review, may I ask you how many laws were repealed after an official review from Congress?
The Council is not entirely sure, but I'm sure my co-counsel can answer that question later on.
Thank you very much.
This provision ensures that the Act remains responsive to evaluating circumstances and technological advancements while balancing national security and constitutional rights. The review process involves public hearings, expert testimony, and data-driven evaluations, allowing for advancements, modifications, and even repeal if necessary. This built-in mechanism underscores the Act's adaptability and commitment to protecting both public safety and individual freedoms. It reflects a thoughtful legislation, narrow approach, not an overreach or vague. This is all in Section 4, Review and Sunset Clause. Subclause 2 of Section 7, it's important to mention, as it ensures the Media Integrity and Security Act is not a permanent fixture, but a temporary response to the current
Counsel,
changes.
could you please clarify for the court, how would you define disinformation and misinformation, and what is the difference between those two?
Misinformation and disinformation, I believe they're both written in the case. Misinformation and disinformation, so disinformation, I believe, according to the case, would be changing the information, and misinformation, the creation of wrongful information that can lead to all of these negative consequences that we're seeing and that have been noted before.
And what do you mean changing the information? Could you clarify that?
As in perhaps modifying a certain date or something that has happened.
Okay, but also in my understanding, the disinformation also includes the intent to mislead the audience that is reading the information that is posted. So my question is here, wouldn't the bill need to actually clarify those terms, since right now me and you are having the disagreement on the definitions of those words?
The Congress believes that since this is still developing, it can develop even further, and it can be modified to include such definitions as well.
But the bill is not being modified right now. The bill has been already passed by the Congress, and it has been already signed into law by the President. So at this point, we can consider whether or not the definitions that are given within the bill are vague or not.
In giving into account that the bill is, it was thoughtfully, thoughtfully thorough. It does include a subclause in which it states that these things are up to changes and assessment on a yearly basis. And so all of these definitions can be restated.
But on a yearly basis, but what about right now? Right now we're a year out from the next possible review. And for a year, the citizens need to understand what actually it means to create misinformation or disinformation. Wouldn't this already create the doubt for a reasonable person, and therefore this would fall exactly under the vagueness doctrine?
Wouldn't a reasonable person have the ability to distinguish between something that is doing harm and something that is not intended to do harm in that case?
But I believe I'm asking here whether or not it has a reasonable person would doubt as to the meaning of misinformation and disinformation. There are different scopes of those terms as well, whether or not to include intent or other criteria within those definitions. So my question is, shouldn't have Congress define those from the beginning and not potentially waiting for the next review to come around? Would that not make the act right now vague under the vagueness doctrine?
The Congress does not believe so, exactly because misinformation is defined at the end, I believe, in a subclause for definition specifically. Misinformation, the term misinformation refers to any false or misleading information disseminated through any medium, etc., etc.
So there is no distinction between the misinformation and disinformation?
Not at the moment.
Thank you.
Proceeding with subclause 2 of section 7, it's not a permanent fixture, simply temporary to the current dangers posed by social media. With the nation facing unprecedented challenges, including an upcoming critical election, the Act establishes necessary safeguards to protect public trust and national security. The sunset provision ensures the Act will expire in 5 years unless the Congress determines that it has to be continued. And this demonstrates that the Act is a measure that is thorough in review. This demonstrates as well that it's tailored to address specific and immediate risks of misinformation while respecting the evolving nature of democratic discourse. The structured approach clearly counters the vagueness doctrine, as it ensures that the Act's provisions are scrutinized, regularly scrutinized, and refined to maintain clarity and relevance by mandating periodic reviews and tying the Act's continuation to measurable outcomes. Congress has built, therefore, safeguards to prevent arbitrary enforcement.
Can you please assist the court and inform the court about the review process in Congress? What are the review process in Congress?
Public hearings, testimonies, and data-driven evaluations.
Thank you very much.
Before you continue, I have one clarification I want to make. So in your brief, you talk about the Papachristou versus City of Jacksonville case, correct?
Can you repeat the name, please? Sorry.
The Papachristou versus City of Jacksonville. It's one of them cited in your case.
Yeah.
So in this case, we talk about what you were just mentioning, the arbitrary enforcement of it. Mm-hmm. And one of the issues is that the wording of the bill in that case, that the law that was passed in Jacksonville, was deemed to incite arbitrary arrest and enforcement. How would you say that the phrasing of MISA will not lead to the same in terms that it's citing the words, what is it? That will incite violence or threaten national security. Do you think that this provides sufficient guidance to avoid this arbitrary enforcement of it?
May you just repeat the specific sentence? Sorry.
So in MISA, there's like these legally recognized terms like the incite violence and threaten national security. And do you think that this provides enough for it to not affect the arbitrary enforcement of the act, as was done in Jacksonville?
According to another case, Holder versus Humanitarian Law Project, the court upheld the law prohibiting material support to foreign terrorist organizations, even when the law restricted some forms of free speech. The law's definition were specific enough to withstand the vagueness challenge, and it misses terms such as threat to national security and the terms you just mentioned. They are linked to concrete harms like terrorism or public disorder, which does ensure clarity in this case.
And just based on a specific nuance of what you just said, in this case that you just mentioned about the terrorist organization or whatever it is, you said that it does, in that case, there was a violation of free speech. So are you saying that there is a violation of free speech in this case, but it's justified? Or is there no violation at all?
That there is no violation at all. This is a case regarding terrorism, criminal, and it's regarding the vagueness doctrine specifically that I'm using this case to, and to say that the court did not state that there was anything vague regarding threat to national security or the terms that you mentioned yourself.
Counsel, I have another question. You are saying in your brief that unlike criminal statutes requiring strict precision to avoid punitive consequences, civil regulatory frameworks like MISA may include general terms to allow adaptability, correct? You are arguing that because MISA doesn't include any criminal penalties, the level of scrutiny should be lower regarding the vagueness doctrine. Is that your argument?
So you're saying that because this is not anything criminal, the level of scrutiny is lower, correct?
As to the definitions of the wording of the act.
Well,
and it's not me saying this, it's your brief, so I'm trying to understand that this is the correct understanding of your argument.
So the wordings of the act are tailored, although they still allow for interpretation that is essential because the world is indeed evolving and things do need to adapt.
Yes, but I'm trying to ask whether or not there should be a difference between criminal statutes and how they are defined and the civil act. Is there a different level of scrutiny as to the definition and the ability of Congress to give a bit more leeway on civil act?
The council is not entirely sure, but my co-counsel can answer that question shortly, as we are indeed running out of time.
You have 2 minutes left, yes.
Exactly. Okay, so I'll yield the time back to co-counsel.
Thank you, counsel.
Thank you.
The respondents have proven here today one thing, that the MISA is completely overbroad in its measures to prevent free speech. The respondents' arguments full of I believes and uncertainties. The court has previously ruled that the government cannot regulate speech based on identity nor content, and the Congress contradicts itself. The Congress contradicts itself, as opposing counsel even says, by having individuals bear the burden of getting accredited they adhere to a code. And I ask your honors one question. Who is accrediting journalists and creating these codes? The entire intent of MISA is based on content, political content, as mentioned by the respondents. But their direct concern is the upcoming elections as to restrict only political information to only be disseminated by government-approved person. Information about governments will then be controlled by the government. And hence, this intent is content-based. If the court decides to uphold the appellate court, they give the government direct access over the use of the First Amendment. They set limitations on identity and content, and this will permanently change the role of the government in our daily lives. And you heard the opposing counsel list other ways citizens can express their rights. But I ask, what is the true purpose of the MISA?
Counsel, I need to interrupt you here. You're talking about the fact that the government agency that will be created will sanction or not give out the accreditation to the journalists based on their political views. However, according to the act, an individual, the only thing that they need to evidence on the application is their professional qualification, such as a degree in journalism, communications, or a related field. There is no possibility for the government agency to include any other restrictions, such as political views. So I'm trying to understand how you're arguing that this is going to happen.
Of course, Your Honor. I was specifically not referring to journalists when I was saying they would be restricting the speech on the platform. I was referring to the everyday citizen, the average citizen in the U.S. who does not obtain or does not have a journalistic accreditation method.
But then how the prohibition is then content-based? Because it is not it's not prohibiting either of the political affiliations to create the speech. The journalists also have usually the affiliation, so they would be able to get the accreditation and create the content on whatever their political beliefs may be. Therefore, how would this be a content-based prohibition?
Well, Your Honor, this is a content-based prohibition simply because of the fact that Congress says itself that it is inspired by the recent political uprisings, the recent assassination on the president. This is content-based, as its aims is directly to prevent and stop the spread of misinformation, the spread of malinformation, disinformation. I don't see in any way that this would not be content-based, as it's directly inspired by stopping political content from being disseminated.
You may continue your argument.
Of course. You heard the opposing counsel list other ways that citizens can express their rights, and in response, the respondents state, national security is above all. Like I said before, the court has always sided with our personal liberties over national security. And of course, the respondents are correct in that there are limits, but these limits are only applicable when using the highest level of scrutiny, and the speech must be extremely specific. And we even see the respondents say that the vagueness, in fact, there is no differentiation between disinformation and misinformation in the bill itself. How is this not vague? And even when looking towards the arbitrary arrests and convictions set in Papa Christou versus the city of Jacksonville, the respondents could not produce a specific situation in which this case is not binding. And if this court decides to uphold the prior court's decision, then it would be setting a precedent like no other, allowing the government to have the power to create vague and abusive laws that limit the First Amendment to everyday citizens. Thank you.
Thank you, counsel.
Oh, if you have no further questions, I will sit.
Are there any questions on the panel?
I want to pose a little hypothetical for you, actually.
Sure.
Something that I was thinking about is some of the first cases that you cited at the beginning in your brief and in your speech regard the publishing.
Yes.
We're in the 21st century where it's not print media. And unfortunately, because of social media and these platforms, misinformation and disinformation can be spread so much quicker, and it creates a much more dangerous situation. So in that regard, should it not be then that we will apply something a bit more strict now to social media and its use instead of how we did with newspapers back then?
Of course, I totally agree with you in the fact that social media should be, in a way, specifically regulated to stop the spread of disinformation and misinformation. I wholeheartedly agree that it is damaging to our political system. However, social media in this case is a public forum. It is being treated like a public forum. And simply put, if the Congress wanted to limit the spread of disinformation and misinformation, then they would have to leave it up to the specific agencies, the specific companies that run the social media, rather than arbitrating over completely everybody in the United States, and in a way creating the differentiation between the public forum and a publishing. If the United States treats social media like a publisher rather than a forum, then it is not a public space anymore.
But then let's say if we want to keep it up to the companies to decide how they're going to maneuver it, or up to the states, let's say if we didn't want to make something federal, wouldn't then that create a fractioning in the system and how it's dealt with? And how would we then not be able to implement the equal protection clause, whether it be under the different companies and how you're able to use those services, or under different state jurisdictions?
Well, all of the cases that I've brought here today are Supreme Court decisions in the Supreme Court of the United States. So the argument essentially that I've presented today alongside my co-counsel would be completely applicable to every state, all 50 states. And again, all of the social media companies that preside in the United States. So this, if a specific company or specific state wanted to limit our rights in the same way that the Congress is doing here, then this argument would still stand, that it shifts the social media from being a public forum to now a government-regulated publication.
Okay.
Thank you.
This concludes the first round of the questioning, and the court will now move into the recess until 4:55 when we will start the next round. Okay? Thank you so much. The Supreme Court is now back in session, and is the petitioner ready? Is the respondent ready? Would the petitioner like to reserve 5 minutes for your rebuttal argument? Okay, so we will have 25 minutes in the beginning. If you're ready, you may come to the podium and start. And for all of the oralists, I would like to ask you to say your full name before you start your argument at the podium. Okay, thank you.
Good afternoon, Your Honors, Mr. Chief Justice, fellow lawyers. Before I begin, I would like to read a quote from one of our founding fathers. Benjamin Franklin once said, "If all printers were determined not to print anything until they were sure it would offend nobody, there would be very little printed." Today, we're here to talk about the Media Integrity and Security Act, MISA, which was ratified on July 23rd, 2024 by the United States Congress. Now, I would like to tackle, first of all, the jurisdiction of this court, because as petitioners, we believe that the right of this court to listen in this case is extremely important. Even though US customary law, taking into account that this is not specified in the Constitution, believes that every single case that involves the United States should mean that Congress must waive its legal immunity and sovereign immunity, this is not the case for cases that involve the First Amendment. Any injunctive and declaratory relief also does not need the United States immunity to be waived. And a federal court has already tried this case. We're, of course, talking about the Court of Appeals of the District of Columbia, which demonstrates that there is legal precedent that both the Supreme Court and any federal court can talk about this case. There have been many cases where this has not been the case, such as Marbury v. Madison.
Excuse me, Councillor, but before we speak about this topic, may I ask you about your standing? Can you explain to the court your standing?
My personal standing, you mean?
No. As a, bringing this case before the court.
Well, we are here representing the Institute of Free Speech and the First Amendment Coalition.
So let me ask you a question. We have a free speech club in Alabama. Can they bring a claim against this law?
Against the Supreme Court, you mean?
Yes.
Well, of course, first of all, they would have to bring it under lower courts, which has happened in this case. It was tried in the Court of the District of Columbia and in the Court of Appeals of the District of Columbia.
May I put it differently?
Sure.
So does anyone have the right to bring a challenge before the court? Do you need to show injury? Do you need to show damage? I'm asking about your interest to bring this case.
Well, of course, in this case, we can bring injunctive and declaratory relief, which means that a case that needs to stop the government from making a violation of rights can be heard in front of the Supreme Court. And also to declare actions of the government unconstitutional. Our brief claims that the MISA Act is unconstitutional, therefore it falls under the jurisdiction of the Supreme Court. And if I may, also taking into account that this case reached a definitive decision in the Court of Appeals of the District of Columbia, we also have a right to present this court in this case thanks to the U.S. Code, Section 281254, Clause 1, which means that if a Court of Appeals has reached a final decision on a matter, it can be brought up to the Supreme Court. And that happened, as I mentioned, in the Court of Appeals for the District of Columbia, and that is why the petitioners are bringing it up.
Excuse me, Councillor, I'm asking a different question. My question is about your standing, whether you have a legal interest to present this case. I'm asking, in other words, does every citizen of the U.S. can challenge every law about their constitutionality? Do we need any enabling act, any executive order? Do we need any law, to affect their rights and change their legal sphere? Or, this is my question.
Well, as I mentioned, if there is a law that is approved by Congress that infringes on citizens' rights, it can be brought up to the Supreme Court as an injunctive declaratory relief. So yes, and if you mean monetary interest.
I'm asking, I want to clarify the facts. So infringes your rights. Does it mean that you try to post a comment on social media and it was rejected? They didn't allow you to post, and therefore you feel that your rights are infringed? Or you think about that in the US we allow abstract review of the laws?
Okay, I think I know where you're headed. What we are asking for is of a face challenge of MISA, which means that the passing of the law is an infringement on citizens' rights, as the law itself violates the First Amendment, which gives us, the petitioners, the Institute of Free Speech and the First Amendment Coalition, the right to present a violation of the rights of citizens within the United States.
May I ask you then another question? Based on which legal basis Congress legislated this topic?
I'm sorry?
Based on which legal basis Congress legislated this topic?
Well,
what is the legal basis for Congress to regulate MISA?
In this case, Congress brings up, I'm sorry. Well, in this case, what Congress is citing is the assassination attempt of a former president of the United States, and they're using that as a basis to pass the act. Of course, Congress is within its right to present the law, and they are doing so by regulating media. I believe I understood your question correctly.
I'm asking whether the federal government has the authority to regulate this topic, or whether it is whether the state governments, they have the authority to regulate this topic.
Well, this does not involve state governments. This is a law passed by Congress. And Congress does have the capacity to pass regulatory acts regarding media. It has done so before, as long as they do not violate the First Amendment. And it is the belief of the petitioners that they have. Okay. Continuing on, the arguments that we have brought up to challenge the constitutionality of MISA fall, first of all, under the First Amendment. The first case that I would like to bring up to you, to this court today, is the case New York Times Company versus United States of 1971. Under this specific case, the famous Pentagon Papers were supposed to have been published by the New York Times, yet the government of the United States claimed that any sort of publication that represented a threat to the national security of this country would therefore not be allowed. The Supreme Court ruled that a threat to national security is not a sufficient argument to establish a prior restraint. Therefore, the argument that we are presenting right now is that MISA is imposing an unconstitutional system of prior restraint, as the arguments that they present is that this law would prevent information that would be detrimental to the national security to be allowed into the public. And of course, New York Times and Company versus United States of 1971 proves that this is not sufficient basis. At the same time, we are also citing Moody versus NetChoice LLC. In this case that was just passed this year, the Supreme Court recognized that social media platforms are private entities that have First Amendment rights, which means that they are considered as platforms and companies that distribute media. Under this assumption, we can say that a social media platform can be equated to, for instance, a newspaper or a publishing company, in the sense that they take citizens and people's productions, opinions, content creation, and they publish it to the general public to access. And if we equate the decision of New York Times Company versus United States and Moody versus NetChoice, we can reach the conclusion that this law imposes an unconstitutional system of prior restraint, not allowing citizens to publish their thoughts, their beliefs, simply because they're not accredited journalists. Now, of course, this could also be an argument against the 14th Amendment, establishing that this act would not only violate the 14th Amendment, but the First Amendment, but my colleagues will talk about that further later. Now I would like to mention another case that we believe is extremely important, which is Lovell versus City of Griffin from 1938. Now, as I mentioned, we have established that social media platforms under previous cases can be equated to any other company that distributes media. And in the case Lovell versus City of Griffin, the court decided that the struggle for the freedom of the press was primarily directed against the power of the licensor. MISA resurrects this unconstitutional licensing scheme, giving the government unprecedented control over who may speak in the modern public square of social media. And I would like to now cite MISA itself. If you would join me in the section 8, paragraph 1.1, MISA defines a social media platform as any publicly accessible digital environment that enables users to generate, share, and interact with content. We believe that this is a very broad description. Of course, when tackling the 14th Amendment, my colleagues will delve deeper into that. But I would simply like to ask a question to all of the honorable justices here. The site of the New York Times, an organization that was previously mentioned in a case. In this site, any citizen can publish, I'm of course referring to op-eds, editorial articles, guest essays, which don't require a license in order to be published. They can share it, they can interact with it. So would the site of the New York Times, an established institution in this country, fall under MISA? This could be an interpretation. And of course, if we start using these very broad interpretations to analyze what can and can't be published and what would require a license, this would mean that the only media system and the only media environment in the United States that would be regulated with such a strong prior restraint would be social media. This wouldn't happen in radio. This wouldn't happen with television. This wouldn't happen with the streaming services. It would only fall under social media.
I would interrupt you here and would like to ask you a question regarding the First Amendment scope. Does the First Amendment protect the speech, or does it also give an individual a right to an audience?
Well, in this case, the First Amendment tackles 4 main parts, which are an individual's freedom of religion, freedom of speech and assembly.
Then the First Amendment right does not give an individual a right to an audience.
To an audience?
Yes.
Well, if we understood speech to be the communication between more than one individual, that other individual could be considered an audience. So a speech couldn't be a single person's speech.
Okay, but I'm leading here to the fact that the MISA Act does not necessarily regulate the speech itself. It's not content-based. It doesn't prohibit specific kinds of speech. It prohibits and limits the right of individuals to have a broad audience on the social media, which is the social media having millions and millions of users. So I'm trying to understand how are you arguing even that it is restriction on the freedom of speech? Because the individuals still can exercise their freedom of speech in different mediums. In offline world, they cannot go on social media and make the content.
Yes, of course, this is true. Any citizen could express their views on any other platform, but this would create a legal precedent for other platforms to be regulated in a similar manner. And that symbolizes an extreme threat to any individuals in this country right to freedom of expression.
Could you then clarify what other platforms do you mean by?
Well, for instance, television, newspapers. At the moment, any American citizen can be published without a license in an American newspaper. This could set a precedent for that to stop.
However, not every single user is just going and publishing articles in newspaper. Neither they're just appearing on a television. You need to have a reputation to be able to actually go and publish an article or even an op-ed in a newspaper. Therefore, this seems exactly what MISA Act is trying to create. The Act tries to create a check against every single person just going on and saying whatever they like to a broad audience on social media. Therefore, I'm not necessarily understanding your argument to the restriction on the freedom of speech and your clarification regarding the television and newspapers.
Well, what I have been trying to explain is that simply because people can still express their views after, for instance, a certification or licensing process under MISA, it's still, in a way, a gag law that is creating a system of prior restraint, and that is unconstitutional. That should be the basis of the case.
But then would you say that the fact that individuals cannot freely go to a newspaper and publish an article also would be a restriction on freedom of speech?
I mean, individuals right now can do that. They can get published by an article as long as the article's guidelines permit it, but this is not regulating the guidelines, this is regulating who can and who cannot present.
But there is still some check to the speech that is created. So
And so there is in social media. Every single platform has their own community guidelines. And if we consider MISA's definition of a social media platform, any website can be considered a social media platform. And it is the fact that these websites and these companies have their own guidelines that regulates content the same way that the New York Times, for instance, has guidelines. Right now, the law that the government is trying to pass is not talking about guidelines on the content, it's about talking about restrictions on who can and cannot express their freedom of speech.
Councillor, may I ask you, so if, let's assume a social media platform, Meta, decides to adopt content regulation and posting regulation similar to MISA, that only accredited journalists can post on Facebook, on Instagram, can they do that? Or would that be a violation of free speech?
Well, every company has the right to determine their guidelines. It would depend. In this case, we are talking about a company that is registered within the United States.
Yes.
And their guidelines, if they are established under US law, it is the belief of the plaintiffs that if they're defining themselves as a social media platform, meaning following the decision that was presented in Moot, this would equate to a violation of the First Amendment, as it is not allowing any citizen who may want to present themselves under the definition that they have of their own platform, it would do so. But it definitely depends. If Meta, for example, were to change its definition of what its company does and its products, this would change. Let's also remember that Meta has an array of products. They have chatting apps, such as WhatsApp, which would fall underway in precisely this law. This would mean that WhatsApp or Messenger, which are used for one-to-one communication, could be regulated under MISA, meaning that every person that wants to conduct a chat online would have to be an accredited journalist in order to do so.
No, my question was whether Facebook, and Meta on their own, they can decide on their own one day, let's assume MISA does not exist, has never passed. Can Facebook, Meta, TikTok make an internal regulation and create two types of users who are audience, and then users who are allowed to post as long as they are accredited journalists? Can Meta do that, or do you think that this will be violation of their freedoms, of freedom of speech?
That would, in the eyes of the petitioner, be a violation of the Equal Protections Clause, as, well, of course, this is not a law, but any sort of regulation of internal regulation of a company that might serve as a violation of the First Amendment could eventually result in, yes, being considered some form of a violation of freedom of speech, as long as this is a social media platform, which, as I said in Moot, is considered as a company that has protections under the First Amendment. Does that answer your question? Okay. Continuing on, I would like to simply ask how many time I have left.
Currently, you have 8 minutes left before your time for the rebuttal argument starts.
Okay. I would simply like to conclude in that case with a small quote by Michel Foucault, who said, "It is the purpose of law. It is the purpose of law to always question itself. What we're here doing right now is questioning a law that was passed." Now, I would simply like to yield my time to my fellow, my fellow counsel, who will talk about further infringements of the First Amendment by MISA. Thank you.
Good afternoon, Your Honors. My name is Giselle Hamadni, and I am presenting the plaintiffs today. Today, we challenge MISA on the grounds that it is unconstitutional and infringes upon free speech and free press, both of which are fundamental protections under the First Amendment. This law establishes a government-controlled press, an alarming and unconstitutional shift that goes against the very idea of a free press as envisioned by the founders. Accreditation as a barrier to expression creates a two-tier system of speech that diminishes public trust in media diversity and public perspective. In Miami Herald Publishing Co. versus Tornillo, this court held that the government cannot compel newspapers to publish specific content, emphasizing the importance of editorial discretion free of government interference. The court ruled that the government cannot interfere with editorial control and judgment essential to the press. MISA's accreditation requirement threatens to control free speech and enforce a controlled press environment that restricts diverse viewpoints, directly opposing the First Amendment's purpose. To allow such a law to pass would not only grant the government the authority to regulate free flow of ideas that is essential to the very own democracy it strives to maintain, but also creates a dangerous precedent that could extend beyond social media and to all forms of public discourse. Second, the Supreme Court has made clear that any law that seeks to restrict speech must be subject to the highest level of scrutiny, strict scrutiny. For the government to justify such a restriction, it must show that the law serves a compelling state interest, it is narrowly tailored to achieve that interest, and imposes the least restrictive means possible. Misa's restrictions are content-based and thus fall under and are subject to strict scrutiny. Under Reed versus Town of Gilbert, laws that target speech based on its communicative content are presumptively unconstitutional and may only be justified if narrowly tailored to serve compelling state interest. This is
Counsel,
not the case.
I'm going to interrupt you here. Could you please explain why do you think this act is restricting content-based speech? And what actual content does it restrict if you are arguing that it is a content-based restriction?
Well, if we all go to the MISA Act, it is restricting any sort of content to be published on social media that could either be referring to misinformation or that my counsel will speak on later on the vagueness doctrine.
But
However,
wouldn't that make the act content neutral? Because it doesn't target a specific type of content or a specific type of political belief or any other specific group of speech or classification of speech.
however, this does not still make it not subject to strict scrutiny. For the law to pass, whether it's content-based or not content-based, it needs to be narrowly tailored and it needs to be least restrictive. This is something that this own Supreme Court held for.
And then for the least restrictive means, could you give any examples? What would be a least restrictive mean in this particular case to make this, to achieve this specific objective, to the spread of misinformation and disinformation?
Yes, of course. It could enhance social media platforms to alter their algorithms to specifically target the misinformation and the things that they assume that would lead to violence and extremism. However, this is not the case. They're banning everyone from publishing anything that you never know could be misinformative or leading to violence. This could be a way to alter the algorithms. However, they're altering everything for no one to be able to speak or no one to be able to express their individual freedoms and civil liberties.
What about the burden on the private companies that it would impose, asking them to specifically come up with guidelines, specific guidelines to which are not going to be content neutral, they're going to be content specific, and alter the algorithms that the companies have right now and use? Wouldn't that impose a very significant burden on the companies themselves?
Well, yes, of course. But if we obviously talk about the social media platforms today, they already have guidelines that specifically target this. This is not just targeting content. This is targeting who is able to speak, which is the actual violation of the First Amendment here. This is something that my colleague previously touched on. We're basically just arguing the fact that it's not mainly about the plaintiffs arguing against violent or misinformative content. This is obviously something that we can all agree upon. However, they're targeting who can actually publish this content, and you never can actually conclude who can actually publish something that is misinformative or could lead to violent acts.
May I ask you, Councillor, can the government make a law limiting the access of minors to social media?
Excuse me, can you repeat the question?
I will repeat. Can the government make a law limiting the access of minors to social media?
Well, if the social media platforms do want to pass this law, then yes. But the government, but according to a state law that my colleague already previously established, Moody versus Net Choice, it makes private entities, including social media, independent of government. If the social media platforms want to enhance this law on their own platforms, then this is justifiable. But the government has no say in this.
And may I ask you something else? Can the government decide tomorrow that every social media platform is banned and they should not allow to operate in the US?
Well, no, because that would not be narrowly tailored and least restrictive unless it has the right basis to do so, which is not the case that we're arguing today.
Thank you very much.
I want to clarify something on what you just said. It just seems like a contradictory nuance in my mind. You said right now that what can happen is that, based on the professor's question, that what can happen is the companies individually can then, on their own volition, basically, do some sort of guidance or enhancing of the algorithm, correct?
Correct.
But that it's not the government's place to do so. Correct. That's what you just said.
Correct.
But when the presiding judge asked what would be a less restrictive way of the government doing this instead of this, that is exactly what you proposed. How do you reconcile these two ideas?
Yes, I would like to clarify. So as I previously said, the Supreme Court has, if it's assessing a law that is regulating free speech, it has to make sure that it's least restrictive and it's narrowly tailored. In this case, they're not actually addressing the content, but they're addressing who can publish this content. There is a least restrictive way to do so, which is alter the algorithm that specifically target harmful information. However, if you actually go on the MISA Act, Section 4, Subsection 2, it specifically says that any information, any content that was posted before this law has passed, whether it is actually misinformative or violent, and even if it's just pure, cannot be shown anymore. In this case, this is not least restrictive. However, if you are counting on least restrictive and narrowly tailored, you need to specifically target the information that is misinformative and could lead to violence. MISA restricts any sort of content that is based before this law, that whether it is misinformative or not or violent.
So in any case, is it the government's authority to do so or not?
If this is a compelling state interest and the information is actually harmful misinformation, then it has the right to do so. But in this case, it's not just targeting that, it's targeting everything.
But in the hypothetical case that we're in, where the case facts do stipulate that there was violence and that there is misinformation and that is affecting the public, society, and democracy, would this not be a compelling aim in the sense that one of the two cases that your co-counsel has brought up are based on Neer versus Minnesota, and this one does give the exception that there are limited circumstances in which there can be an exception to the prior restraint, one of them being national security. Would that not be applicable in this case?
I can answer your question within 2 points. First, speculative fears do not completely satisfy the compelling interest standard.
But is it speculative fears if we have the facts that there were an assassination attempt and that there were events leading up to the creation of this law and the passing of it? It's not speculation.
It is speculative to assume that all creators are going to be posting information that is misinformative and leads to violence. That is what MISA Act is imposing. It's assuming that all content creators are going to post misinformative information that's going to lead to violence and extremism, which is not the case. Moving on.
Counsel, you have 30 seconds to finish your statement, and then you'll have 5 minutes on a rebuttal argument.
I would like to yield the floor to my
Counsel, if you...
30 seconds?
Yes, you can either continue with for 30 seconds or you sit down and then we just go with the respondent.
Okay, the counsel would like to rest.
Thank you, Counsel.
Chief Justice, Honorable Justices, fellow opposing counsels, good afternoon. I am Niccolo Milanesi, and today I have the privilege to represent the United States of America, appearing as respondent before this court. Petitioner challenges the Media Information Security Act, MISA for short, passed by the United States Congress, alleging that it conflicts with the First Amendment to the US Constitution, it is invalid under the vagueness doctrine, and it violates the Equal Protection Clause to the 14th Amendment. Today, the United States responds that this court has no jurisdiction to adjudicate this dispute, due to the doctrine of the United States immunity from suit. In any case, the United States rejects petitioners' arguments for the act's invalidity on grounds of unconstitutionality and non-adherence to the vagueness doctrine. I will address the question regarding jurisdiction, while my co-counsels, given the socio-political importance and resonance of the allegations made by petitioners, will nevertheless argue the merits of this dispute.
Excuse me, Councillor, may I ask you, what is the legal basis for Congress to make this law?
Congress makes laws because Congress is the legislative branch in the United States of America, and therefore it's given by the very Constitution of the United States, due to the will of its sovereign, the people of the United States, the ability and power to make legislation such as the MISA Act.
Yes, but my question is, does Congress has the authority to make this law, or the legislative bodies in the states?
Oh, if it's right, I get that. Okay. Congress has the authority, Your Honor, to make laws that have a federal application. It's done so extensively. Later on, I will refer to, for example, the Federal Tort Claims Act. Although, obviously, in certain cases, states also have powers to make laws. This is a case in which Congress has made a law that is applied at a federal level. I shall now commence to explain why this court lacks jurisdiction to try the United States of America in the present dispute. The Supreme Court of the United States has maintained throughout history that the United States may not be sued in its own courts, establishing what is known as the doctrine of immunity of the United States from suit. It is in fact consistent with the very notion of sovereignty that the sovereign may not be put on trial by the judiciary upon which it itself conferred power. This very court gave formal origin to the rule of immunity in 1793 with Chilton v. Georgia, when Chief Justice Jay, in his obiter dictum, stated that when it comes to the liability of the United States, I quote, there is no power that the courts can call to their aid.
Excuse me, Councillor. Can you please explain to us and make it a bit more practical? So we have a law passed by Congress, any law. So let's assume we have the Judiciary Act, the first law, the Judiciary Act of 1797. So based on the doctrine of immunity, there is no way to challenge this law before the courts?
Absolutely not. The laws can be challenged, Your Honor, before courts, and Supreme Court has done this consistently throughout history. But this is when the United States does not appear as a respondent, not as a defendant in the courts, because, as I will further explain, it benefits from state immunity. Therefore, the United States Supreme Court does not have jurisdiction to put the United States on trial as a defendant, except when Congress waives that immunity.
And then who should be defendant?
Who should be the defendant?
Yes, so in this case, in the MISA case.
Oh, the defendant will be very likely a private party that's been injured, but this is clearly not the case, and then brings a claim alleging the invalidity in terms of unconstitutionality of the law based on which the let's say, executive action has been brought by the state.
So may I ask you, let's assume that the government makes a law according to which every car in the automobile industry must be electric or partly electric.
Yes.
So parties, they should sue the private companies, Tesla, Ford, or they shouldn't file a complaint against the Agency of Environment. Against who they should file the complaint? This is my question. Who is the proper...
But parties ought to have been somehow become interested in the issue, meaning that they've been, I don't know, injured, I'd say, by actions brought by the state, for example.
Okay, thank you.
So, yes.
Counsel, I would like to continue with the state immunity that you're referring to. It is my understanding that you're taking the state immunity which stems from the Constitution, Article 3. Is that correct?
It is correct.
Then, in your brief, you state that the state immunity protects the United States to be as a defendant from any suit in the courts of the United States unless the Congress gives the permission or waives this liability. Is that correct?
It is correct. This can happen in specific instances. And when I talk about state immunity, it concerns the United States as a state, which, for one exception, in which anyway was established that the court didn't have jurisdiction, never appeared as a defendant. But it also concerns officers, more commonly, of the United States.
Then my question is that this specific case rests on the U.S. Code, specifically Title 28 of it, and the paragraph 1346, which specifically refers to United States as a defendant. And the point 2 says that the district courts shall have original jurisdiction concurrent with the United States Court of Federal Claims of any other civil action or claim against the United States not exceeding $10,000 in amount, founded either upon the Constitution or any act of Congress or regulation, and so on. Wouldn't this be a particular case that we are having in front of us right now? An act of Congress, the case is based on a civil claim, the petitioners are not given currently the damages, which I would assume would not exceed $10,000 in amount because it is the injunctive relief, so before the damage actually occurs. It is based on an act of Congress and the Constitution, and the United States can be a defendant since the U.S. Code was passed by the Congress. Therefore, the Congress created the waiving of the immunity for any civil action under this code.
But the civil actions that fall under the scope of the code you're referring to, Chief Justice, is not one that is being brought against the United States today. In fact, petitioner alleges that the law passed by Congress is unconstitutional and seeks an injunctive relief. That is not something that falls within the scope of the exceptions that allow for state immunity to be waived by Congress. As I was saying,
but I'm not talking about specific exceptions that are written within the Constitution. I'm asking you whether or not the U.S. code upon which this case rests creates a permanent exception to the United States immunity to appear as a defendant for any civil action or claim that does not exceed all of the things that are said in the Act, which is founded either in the Constitution or an Act of Congress, which both of the parts are present here in this case.
And I answer that it does not, because in the history of this court, it has been established that the United States does benefit from immunity, except for when Congress waives it. And the only practical case that we found, although this concerns mostly, as I already said, offices or entities of the United States, never the state itself, is under the scope of the Federal Tort Claims Act, which is obviously not applied in this case and not the ground on which a petitioner filed this case. In any case, the doctrine I'm referring to has been established through a series of cases, and as I previously mentioned, except for one case in which the United States was deemed...
I'm sorry for interrupting you right now, but could you please specify what was the date of the case that you're referring to on the United States Supreme Court?
I assume you're referring to the first case I mentioned,
Yeah.
Chilton v. Georgia, 1793.
This case has...
I am aware.
Yes, this case has been ruled 100 years before the United States Code has been passed. Therefore, you would not be able to lay your argument on the United States, the Supreme Court case, since it is very outdated.
I am aware, Your Honor, I'm not using the case as a precedent. I'm using it as the first instance in which this very court, and it's been ruling so consistently throughout the centuries, has established the doctrine of immunity. There's other cases, Coins v. Virginia, 1821, United States v. Lee, 1882, and up to the Kansas v. United States, 1907, and the Federal Tort Claims Act, which is, in fact, an exception in which private parties may sue the United States as a defendant, and that dates back to 1949. Relating back to the present dispute, since Congress never waived the United States immunity, nor does this case fall within the scope of the Federal Tort Claims Act, private parties, because private parties have not suffered damages in the present dispute and have not brought, petitioner has not brought the lawsuit based on such allegations of damages, it should not be up for debate that the United States unequivocally benefits from immunity in these proceedings. I thank you for your attention. I would now like to yield my time to co-counsel Baumeister, who will begin arguing the case on its merits.
Good afternoon, Honorable Justices. I am Lily Baumeister. May I first ask how much time I still have left?
20 minutes exactly.
Okay, thank you. So, notwithstanding the question of jurisdiction, this case is not legally sound based on its merits. I will stand here to argue that MISA is in fact not only within the limits of the Constitution, but rather that it was necessary for Congress to adopt this act in order to preserve the greater interests of safeguarding national security, stability, and safety. With MISA, Congress is not attempting to limit free speech. Rather, it is limiting the spread of polarizing misinformation that can be mass disseminated on social media platforms, a threat of which the costs greatly outweigh the ability of any individual to post unlimited content on social media. Millions of users are active on social media every day, using a range of apps with mass content produced daily. But in such critical times as are now, which I will further go into, that are especially heightened by the attempted assassination on the former US president, Congress had the duty to take action in order to protect American values of safety, security, and democracy. It is crucial to note that MISA is not intended to be a permanent measure, but rather a temporary one. It has a 5-year time limit. Hopefully, within this time, companies will be able to develop technology and algorithms to completely detect all forms of misinformation, deepfakes, forms of speech threatening our core values. However, until then, Congress saw no other means but then to take this measure to protect our society. For example, during the COVID-19 pandemic, the restrictions of assembly in public were also within the limits of the Fifth Amendment, which I know is not the one question right now, but because it was a case of national emergency, Congress had to take those measures in order to preserve society. So the catalyst of this that led to the introduction of MISA was the attempted assassination on the former President Kennedy Jefferson. The content on social media is extremely polarizing right now. It is dividing people, heightening false information, and provoking the public. There have been destructive...
Excuse me, Councillor.
Yes.
May I ask you, so do you believe that an attempted assassination justifies the compelling state interest in order to limit free speech?
Absolutely. Because of the polarizing nature of social media. Right now there are destructive riots, there have been damages to property, there are conspiracy theories that are undermining trust and dividing society, creating suspicions in the very functioning of our own democracy.
And may I ask you, who prevents journalists to post misinformation, to post conspiracy theories?
Well, journalists post on a newspaper.
Well, you know, I mean on social media. For instance, can we have a journalist from Fox or from other platforms posting in social media conspiracy theories?
I mean, that could be the case if it is not currently regulated. And although there are many social media apps that are trying to put in some regulations, for example, I think Meta is researching and creating algorithms to stop this kind of misinformation. The current case at hand is there's too much content to be regulated, and the attempted assassination, which is a direct threat to one of the main figures representing the United States of America and our democracy, just shows how necessary it is that we quickly take an emergency measure, slow it down, and then from there we can continue our research and find other ways to deal with the spread of misinformation.
So may I ask you, do you think that one attempt assassination against a person justifies a state of emergency and to curtail human rights?
Well, we have not currently declared a state of national emergency. However, with the environment and the intensifying and polarizing situation, it could very well be the case. And so in order to prevent this, we have adopted MISA.
And there was no alternative way to achieve the same goal, for instance, to impose on social media platforms, to use better algorithms to hire more people as content managers in order to achieve the same goal?
At this current state of technology, it is not feasible. We took the measure we believe to be the most necessary. And that's why it's only a temporary one. It's only for 5 years. In 5 years, there can be a lot of technological advancements.
Thank you.
So,
Council, I would like to ask a question regarding the attempted assassination and your connection to the fact that the assassination has happened because of the social media. Has it been ever evidenced to any extent that this was the leading cause of the attempted assassination? Because I understand that the Congress says so, but on what are they basing this conclusion?
well, as I'm sure the Congress is competent and has its very good sources, but yes, we do believe that that was the reason, because on social media, especially now, it's extremely divisive. There are echo chambers where people are inciting violence with hate speech. There can be false claims that incite mob violence. And we believe because of this heightened and intense environment, that's why specifically a public figure was targeted. He's the spotlight of social media. He's our former president. And so that's why we do believe that that was due to social media, yes.
You may continue your argument.
Thank you. So yeah, the Pizzagate conspiracy theory of 2016 also showcases how based on conspiracies, people can bring these conspiracies to real life and take real life action. For example, in that case, a North Carolina man went to a pizza shop loaded with guns and fired. So yeah, these circumstances that I just listed essentially highlight why MISA was necessary, and now I will go into the constitutionality of it. So it is important to note that the First Amendment is not an absolute right. There are limits to it. And there are several examples. For example, it can be limited in instances of true threat, wartime, defamation, judicial contact, regarding like criticisms of judicial conduct, fighting words, child sexual abuse materials, and public morality and decency. So these are just like some cases in which it can be limited, just to exemplify like that it does happen quite often that the First Amendment has like is not like absolute. Chief Justice Warren Burger even stated himself in the decision of Chicago Police Department v. Mosley that the First Amendment does not literally mean that we are guaranteed the right to express any thought. And to reiterate, in this case, Congress is not prohibiting free speech. We are limiting posting on social media to so that individuals go through an accreditation process to ensure they will post reliable content that is easier to monitor. The content they will post, whatever, if it wants to be about restaurants or about some kind of a debate, that is not monitored. They can do it. However, it just must be within the limits that are allowed. So not disinformation, it can't incite violence.
So, Councillor, may I ask you, so it's not okay if ordinary people spread misinformation, but it's okay for accredited journalists to spread misinformation?
No, absolutely not. The spread of misinformation is the problem. But with the enactment of MISA, well, first of all, the likelihood of it happening will significantly decrease. And as there will be presumably fewer people acting as active posters on social media, it will be much easier to regulate the content they are posting.
But don't you think that if we create a system where we have accreditation, which means that some people, they will have authority, then these people, when they spread misinformation, based on that authority, their claims will be, they will have more chances to be followed by the ordinary people?
I see what you're getting at. First of all, anyone can become accredited if they wish to, so we are not discriminating based on this. Second of all, once they do post, because there will be fewer people, we will be able to monitor, and we will be able to discard what they are saying to the public openly, and then they will lose their accreditation immediately. So yes, like maybe for a temporary moment, people will believe them, but then we will have measures to like discard that and prove them wrong.
So in reality, then it's content regulation, with the sense that if we do not like the content of a journalist, then we will remove their accreditation.
It has nothing to do if we like the content. It has to do with if the content can be classified as misinformation or disinformation.
Who will decide that?
Well, we will have, we will probably make an office that will have various fact checkers and stuff like that to verify the information.
Thank you.
And Council, one step back, could you define for us what is social media?
Social media, I also believe it is defined in MISA, but it is the apps where people post their content. So like examples would be Instagram, Facebook, X, TikTok.
Exactly, so people, therefore we will be modifying what social media are, right? What social media is, because now it won't be for the people, it won't be only for the people who is accredited as a professional journalism. But we're speaking here about this accreditation that is short of showing an ID. How do you get accredited as a professional journalism?
Like as a journalist, or how do you?
As a journalist, yeah.
Well, although I'm not too educated on how to become a journalist, I'm sure there is a regulated process they must go through, and then they can start.
But let's say that you have to go to school and spend some years there. And do you think it is fair that it is not, that you are not creating a special class of people, because the social media is for the people? You are creating and restricting it too much for what the purpose of social media is. Do you think it is fair for a regular citizen, and that's what social media is for, to post 4 words in a social media platform to go through a school of 4 years?
I see what you're getting at. First of all, it is important to note this is a temporary measure that we're only taking because we're in a state that is close to national threats to national security. And second of all, people can still communicate of this kind of form just within more private group chats, for example, on iMessages. So people will still be able to do this. Yes, it is true, they will become limited, but they are becoming limited for the greater purpose of preserving national security.
And how do you, because you defend yourself with the limitation of time, how do you respond to the argument that that limitation of time is only with the purpose of controlling the next or the upcoming election?
That is not our goal. We're not trying to control any election. We're trying to stay neutral from that. We're just seeing that because of the circumstances right now, the attempted assassination, that is the measure we decided to take. So, yeah.
Okay, and could you specify with more detail how content, like you mentioned before, sexual abuse, for example, affects national security?
I mean, in that case, it doesn't affect national security per se, but it still affects the American citizens and our core values of not viewing pornographic content of minors, for example, or sexual exploitation. I mean, that's infringing upon other human rights, even more of a reason to restrict it. So, yeah.
Okay, but in this specific example with MISA, how or what type of content are we trying to prevent by blocking everyone which is not a professional journalist to posting? Because I don't know if this is...
Well, we are mainly just trying to block hate speech and all like the types of speech that are already with case law like limited by the First Amendment, and then also the spread of misinformation and disinformation, which at this time can have very detrimental consequences. May I also ask how much time I still have?
You have 7 minutes left.
Okay. Okay, so essentially, I argue that it is within the constitutional limits. It is preserving and safeguarding the greater values of American democracy. And I heed the floor to my co-counsel, Fiona Fenstermacher.
Good afternoon, honorable justices. My name is Fiona Marie Young-Fenstermacher, and I will now address petitioners' arguments on the vagueness doctrine and equal protections clause of the 14th Amendment of the US Constitution. The vagueness doctrine protects citizens from laws that fail to give adequate notice of prohibited conduct or could lead to arbitrary enforcement. However, there are several reasons that the MISA does not violate the vagueness doctrine of the 14th Amendment. Parker v. Levy has established that it is not desirable for the judiciary to invalidate a law based on unclear criteria. This case demonstrated that a statute is not invalidated simply because difficulty is found in determining whether certain marginal offenses fall within their language. Further, it emphasizes that it is impossible to predict all scenarios in a single statutory text. In line with this, judges should be able to interpret text without invalidating the whole statute. Allowing a certain extent of discretion of the court is a part of the very element and nature of common law jurisdictions, and asserting the fact that a statute should not be invalidated simply because because it requires a certain level of interpretation. Moreover, the vagueness doctrine is typically applicable to criminal law cases, not in civil law cases. In Connolly v. General Construction, a statute was struck down as unconstitutional under the vagueness doctrine. However, this is a criminal law case, and it is necessary for the terms in the statute to be more specific and more clear because of the severity of the sanctions. MISA does not intend to enforce punitive consequences in a criminal law jurisdiction, and therefore does not relate directly to the Connolly case and does not prove invalid under the vagueness doctrine.
Counsel, I'm going to interrupt you. Can you please clarify again whether or not the bill is imposing any criminal sanctions?
The bill does not impose criminal sanctions, Your Honor.
Are you sure in that statement?
Yes, Your Honor.
Under Section 6, sanctions and penalties for non-compliance, under Section 2, the bill states any individual found to be actively circumventing the content restrictions outlined in this act, whether through the unauthorized use of social media to disseminate misinformation or the evasion of platform protocols, shall face both civil and criminal penalties.
Okay, well, disregarding that argument, I will continue with my further arguments, if that's all right, Your Honor.
You may continue, yeah.
In line with the concept that the vagueness doctrine is inconsistent and challenged consistently throughout case law. In Holder v. Humanitarian Law Project, a statute was found to be not vague because assisting a terrorist organization can help legitimate that terrorist organization. However, in Skilling v. US, the statute was found to be so vague that any citizen could easily be accused of violating the statute from practically any action. Therefore, this discrepancies from one extreme to another using this doctrine shows the extreme inconsistencies, and this inconsistency of the application of the doctrine calls into question the effectiveness and the legitimacy of the applicability in general. Similarly to the inconsistent application of the doctrine itself has been questioned by several judges. Justice Thomas states that the use of the doctrine has become, and I quote, a bad habit invoking due process clause to constitutionalize rules that were traditionally left to the democratic process. I will now explain why Section 8 of MISA contains provisions that clearly define what constitutes misinformation, as well as provides guidelines to who can be considered an accredited journalist. MISA contains a list of prohibited content, including incitement of violence, disruption of public order, and threat to national security. Public order clearly has protection of citizens' rights to free speech so long it does not lead to violence or civil disorder. In Papachristou v. City of Jacksonville, it was decided that a statute was vague because it failed to provide fair notice to individuals about what conduct was forbidden, and that it was too vague for the general public to understand. However,
Counsel, I'm going to interrupt you again. Regarding misinformation and disinformation definitions, does the Act provide any definition to the disinformation term or only misinformation?
While the Act might not provide an exact definition of disinformation, it prohibits both misinformation and disinformation, and the Act itself is looking with the goal of intending to prevent incorrect information on platforms, and that is what we need to look at. Not what the method of incorrect information is, but rather the result, which is incorrect information being published on social media platforms.
But since both misinformation and disinformation are prohibited, wouldn't then you require the Congress to define both of the terms?
I believe it's sufficiently clear to anyone who reads the bill what is prohibited, and that is incorrect information being published on social media platforms.
You may continue.
Before you do, I do have a clarification. You want to talk about the prevention of said misinformation, correct? Through MISA.
Yes, the prevention of misinformation, disinformation, incorrect information.
And we continue talking about democratic principles and whether it be freedom and liberty and justice for all, correct? But how do we reconcile the idea of MISA and applying it with the sense of it not being too paternalistic in its application?
Paternalistic?
Paternalistic is defined in the sense of, let's say, an act or a law being something that is the government deciding what is best for the people without the people actually deciding what is best for themselves. So we talk about the reliability of the information out there. Should it not be up to the people to decide what is reliable and what they choose to believe in, and not the government choosing for them? Where do we draw that line?
Yes, Your Honor. Well, the government, the people, it is stated in the Constitution that the people choose the government, and they give the power to the government to make decisions for the people that are the best of the people. And this is an essential part of American democracy. This is democracy in itself. This is sovereignty. This is the fact that the people give the power to the government to make the correct decisions for the people, and that is how I would defend
And
that.
democracy is also based, let's say, on Locke's social contract, in the sense that you give the power to the government and you're relinquishing part of it. But if the government is taking away or limiting your speech and your ability to protest to a certain degree through an open platform that is very commonly used in the 21st century, is it then not breaking that trust with the American people?
I would argue that this is not relevant to what the argument that I'm making right now. However, I will still address it. Yes, the government cannot infringe on the rights that are created in the Constitution of the people. However, there are instances, as my co-counsel has stated, that the government has the right to infringe on these rights, not to infringe on them, but to limit them. We are not preventing anyone from posting on social media. We are just simply making a accreditation process that anyone can go through and that anyone can become accredited through.
But may I ask you, so
Yes.
if anyone can go through the accreditation process, then what is the value of this law?
It is to ensure that people who are posting on social media platforms have gone through this process and who are
ethical. But if everybody, so my question is isn't it an unnecessary burden? If everybody can go through the accreditation process, don't you think that this will create an unnecessary burden to everybody to go to this accreditation process?
Yes, Your Honor, I see your point. However, only individuals who are very passionate and interested in sharing information and sharing correct and valuable information would take the time to go through this accreditation process. And
sorry for interrupting, but so let's assume that we have people who went through this accreditation process and they still spread misinformation or disinformation. How are the government is going to regulate that, to control that?
It is very possible that someone who went through the accreditation process can still spread misinformation. However, because it will be a much smaller number of individuals sharing information on these platforms, it will be much more manageable through the government to ensure or to impose sanctions on those individuals who are.
So the idea is that the government, under the First Amendment, has the power to monitor free speech and decide which speech is correct and which speech is not correct.
The government has the right to protect national security in a time of societal vulnerability by limiting who can publish on social media, yes.
Based on which provision of the Constitution?
Based on the first article of the Constitution, which gives legislative powers to the Congress.
To legislate on everything, on anything?
No, but it gives specific powers to the Congress, or to the legislative body to create laws that are necessary, especially when they are protecting the national security of the citizens.
Okay. Thank you.
Yes, Your Honor. Okay.
Counsel, before you continue, I would like to ask the justices if there are any further questions.
Yes, I would like to ask Counselor, is all misinformation under the MISA, would all types of misinformation, despite its content, be considered to fall under the MISA? Basically, I'm saying if it's misinformation regarding non-political elements, would that still classify as information that falls under MISA?
Yes, Your Honor. The MISA classifies all misinformation, all incorrect information as misinformation.
My question then goes, if the idea of MISA is to protect, as you have stated, well, national security, how does misinformation, for example, regarding what is inside a hamburger, for example, how does that affect national security?
I understand that there can be misinformation or even other correct information that is limited through the Act. However, as I've stated before, this is a specific time in this country that is very vulnerable. And although we may be limiting things that may not exactly endanger the national security, we are also limiting things that will endanger the national security, and we view it as essential to protecting the national security of this country. I would like to conclude this point by reiterating that the severity of the consequences that this Act intends to protect, such as public safety and the preservation of national security, are grave. Such act that prevents severe consequences shall not be found invalid due to an inconsistent and challenged doctrine. It is not sufficient to determine this case on the basis of a doctrine that has been consistently questioned. May I please ask how much time I have left?
The time has finished. We have went over time.
May I make one final concluding sentence or no?
Yes.
Thank you, Your Honor. For these reasons, we respectfully request that this court dismiss the case as inadmissible on the grounds of state immunity. If this court was for the first time in history to deny the U.S. immunity in its own courts, we request for it to affirm the decision of the United States Court of Appeals. Thank you, Your Honor.
Thank you, Counsel.
Good afternoon, Your Honor. My name is Rafael Avilés, and I will be doing the rebuttal for the petitioner. Opposing counsel has referenced time and time again that anyone can be accredited under MISA. But MISA establishes professional requirements in order to be accredited. You have to have a degree. You have to have professional experience. And these requirements set a high standard in order to even enter the public sphere online. This flies directly against this very court's decision in Schneider v. State of New Jersey, 1939, which determined that freedom of speech cannot be limited by finance or education. The United States has a 46% rate of the population that holds a third level education degree. Only 46%. That means less than half of the US, if this law were to pass, would be allowed to express their opinions, be it false or otherwise, on the public sphere online. Justice Roberts, in this opinion, stated, "Public spaces for expressive activities is part of a fundamental liberty." In that very opinion, he also said, "So long as legislation does not impair the freedom of speech and press, this United States may control the abuse of these liberties." We do not deny that MISA seeks to prevent damage to society through misinformation. The government has a right to prevent and secure the liberty of people and their safety. But by implementing this draconian law, most people would not be allowed to speak. We will also touch upon the opposing counsel's claim that this law does not hold within the 14th Amendment vagueness clause because it is not a criminal law. Unfortunately, this law is quite criminal. I mean, if you go against it, you will see punitive damages that include up to $1 million in fines and up to 5 years of imprisonment. I mean, just to push forward this point, manslaughter with a firearm gets you 5 years in prison. So speaking in a way that goes against what the government says is misleading or untrue, and the government is the one that establishes this, can get you imprisoned.
Counsel, then I would like to ask you, which provisions of the Act are you referring to as vague under the vagueness doctrine?
Okay, in the vagueness doctrine, in this case, Section 5.6a mentions about the independent journalists, and Section 5.2a, b, c establishes what a journalist is and how he will be vetted in order to express his opinions, his or her opinions online. They must have a degree, professional experience, background check, and journalistic integrity. I would like to ask this court what journalistic integrity means. The Act certainly doesn't define it. It establishes an independent body under the executive branch that should interpret it somehow. But that is quite ridiculous.
But then do you argue that every single act or bill or any statute that is passed by the Congress or the state legislative body needs to be fully defined conclusively on every single term that is used within the statute?
Certainly not, but this is a statute that infringes upon the First Amendment rights, and that requires narrow tailoring, and this is not very narrowly tailored. It affects most people of the United States.
Yes, it affects most people, but then the fact that what most of the people need to understand, and which is, in my opinion, is quite defined, is the fact that you cannot create content unless you're an accredited journalist.
Okay.
Then the requirements that are applied to the journalists are then need to be interpreted or understood by journalists, which is a higher bar for education and knowledge as well on the topic. My point is that the vagueness doctrine requires for the test to be passed, a reasonable person needs to understand the meaning of the law, what is prohibited, and what is allowed. In this case, a reasonable person would need only to understand that they can create content only if they're accredited journalist. Would you agree with that statement or not?
Fair enough, but a reasonable person has the right to speak. It is their duty. The state has the duty to protect their right to speak.
They do have the right to speak. No one is limiting their right to speak. No, but this is denying the platform, denying an audience which you can receive just being in your house on your couch and just sending a tweet or something. It denies the audience, but it does not deny the ability of a person to express their opinion, express their speech, and go out on the street. The freedom of association is still not denied. It's not restricted.
Sure, freedom of association is not denied, but at the end of the day, this is the modern public square. And if a person were to publish their opinion online, it is not guaranteed that they will have an audience. I agree with you on that. But they still can publish it, and it is publicly viewed. These are public platforms that anyone can access. And this restricts whoever can actually publish. At the end of the day, it is so broad, it's so vague, that it doesn't even determine if you can publish art. I mean, it just says you cannot publish misinformation, but art can be expressive. It can be interpreted in many ways, and it falls under the state's decision to determine what is right and what is wrong, what is true and what is not.
Excuse me, Councillor, may I ask you, do people have the right to be users in social media?
They have the right to join if they choose, under the guidelines of whatever the website is.
And the companies, can they restrict this?
Within their guidelines, yes, they can. So, but once inside, if they publish within the guidelines, they can publish whatever they want. But the state cannot be the one limiting them. This is a state legislation at a federal level, mind you, that will impose a blanket regulation.
But can the state decide that, I asked this question, can the state decide that minors, they cannot be users and they cannot make posts on social media?
On regard to that, this has already been touched upon by this court in 2004. Ashcroft v. ACLU, 2004, it was a case concerning the Child Online Protection Act. In this, the court decided that the community standards that were set upon in this law were not sufficient enough to ensure that this law could pass. The court decided that the government must demonstrate that the statute is the least restrictive means of achieving its compelling interest. If less restrictive alternatives are available, this statute failed strict scrutiny. So on the regards to child protection, this court has already demonstrated that unless it is extremely narrowly tailored and very well defined, and everyone still has the access to publicly speak within the law, the government cannot infringe upon the First Amendment.
So there's no limit on the free speech?
There is limits of free speech. You cannot defame a person. You cannot incite violence. But this prevents people from speaking outright. Because even once you're inside, this court has already said.
So my question is, do we have a right to spread disinformation?
You don't have the right to spread misinformation. You have the right to speak. But this law would prevent you from speaking in the first place unless you're an accredited journalist under the standards of the government.
How did people exercise the free speech right before social media?
By publishing what people may decide as expression. They post memes, they post op-eds, they post music, TikToks. I mean, that is expression in one form or another.
So my question is, how did they exercise, how do the people exercise their free speech before social media?
By publishing on social media, and this is being prevented. Because
before social media, my question is before social media.
Before social media, they would write op-eds to newspapers. They may go on radio shows. They may stand in the middle of the street and talk.
Who prevents them to do it right now?
Right now, before the law or after the law?
After the law.
The government is preventing them because they're not allowed to join social media.
With MISA, people, they are not allowed to speak in a podium, in the classroom, in a restaurant, in a public space, with their friends in a restaurant.
It's not preventing them from speaking in public physical spaces, but nowadays it has been determined time and time again that the social media sphere is a public space where public discourse takes place. The government itself publishes its own updates on what is going on through social media, through its social media accounts, in a public manner as a public service announcement. And so that would constitute a place where people should have the right to express themselves freely.
I just want a quick clarification. Then I think this is an interesting nuance. But if companies, these social media platforms are private, and you're saying that people have a right to be a user, wouldn't it be more a privilege than a right?
Sorry?
How do we say that anyone has the right to be a user to a social media platform? Wouldn't it instead be a privilege that you get to be one if there's limitations to it? For instance, we can even look at like the 14th Amendment when we say that if you go into a candy shop and they say that the owner has the right to reserve the refusal of service.
Mm-hmm.
Could we say the same for social media? If the companies that are private are saying you don't have a right, it's a privilege, it's not public, it's private.
At the end of the day, these are, yes, private entities that allow for public discourse. And it has been stated before by my colleagues that in previous cases, this very court has already established that social media companies enjoy First Amendment protections. I believe it was a decision made in 2024 that established this very protection. And so yes, you have the right to deny entry to a space, but you're not allowed to discriminate on that. I mean, there is protections that you cannot discriminate based on race. You cannot discriminate based on sexual identity. So even when you are limiting who can access, you have protections for everyone involved.
But then are you saying in this case it's discrimination?
It isn't discriminatory. This law appears neutral in its face, but at the end of the day, it goes against what Yigwo v. Hopkins says, which is an evil eye and an unequal hand. These background checks can be arbitrary. The journalistic integrity can be arbitrary. This goes against the Equal Protection Clause.
But counsel, how is that discriminatory then? Discriminatory against what? On basis of what characteristic classification it is discriminatory?
Because it allows for potentially discriminatory actions when giving licenses to whoever may speak.
Based on what classification? What characteristic? Discrimination on what between the two people?
I mean, the law itself establishes that you need to go through a background check. And that background check is performed by the government so that your previous work upholds journalistic standards. That means that a person is sitting behind a desk and looking at you and your work and saying, yes, this meets journalistic standards, or maybe it doesn't. And it falls upon a vague definition that a person can just decide with a coin toss, essentially. And that is what Yigwo v. Hopkins essentially says, that yes, it may appear neutral, but if in its act it falls upon a person to make a decision in the moment, a spur-of-the-moment decision, it is not actually neutral, and it actually
Counsel,
deals an unequal
I would
hand.
like to go to your argument that also the justice have brought up. You have said that a person has the right to deny entrance, but they cannot discriminate. And then you mentioned gender, religion, age, and other characteristics that pertain to the identity of the person and that cannot be changed at will by the person. Mm-hmm. However, I'm trying to understand, do you also then argue that the professional discrimination also unconstitutional?
The professional discrimination could be considered unconstitutional, as Snyder v. New Jersey states, which said that freedom of speech cannot be limited by finance or education. And and the professional requirements would be a limiting factor. But
we're not talking about freedom of speech. We're talking about access to the social media and creating content. So by your argument that the professional discrimination can also be unconstitutional, for example, then people who are denied access to an FBI building because they're not working there and they don't have access because they are not professional agents of the FBI, would you say that this would be unconstitutional as well?
No, but what would be unconstitutional if a person stands in front of the FBI building within the public sphere, like the street in front? They have a right to express themselves freely in front of the FBI
and
building.
they have the right to do the same thing with the passing of the bill.
No, because they cannot go on social media. We're not talking
But-
about
but
physical
you're talking-
spaces. We're talking about the digital spaces that act as public spheres. And this law limits those who can access the digital public sphere.
But exactly, the digital sphere is not the same as physical. And the First Amendment has been created at the time that we did not know about the fact that at some point the digital sphere would come into the existence. Are you asking this court to extend the protection of the First Amendment to the digital sphere as well, which is not originally covered by the Constitution at the time of the creation of the Constitution and the amendments?
Yes, law is ever evolving. At the end of the day, you have to adapt whatever has been written 200 years ago to the constraints and the limitations of today.
Thank you. Your time has finished.
Thank you, Your Honor.
Thank you, counsel. At this point, the oral arguments have concluded for both of the rounds. The panel of the judges will go now into the room and we will go into the deliberation and we'll decide on the decisions of the both of the cases. So we'll decide to the content, so to the questions whether or not we affirm or reverse the decisions, and then we will also decide as to the first and second place of the competition. It will be announced to you as soon as we finish the deliberation, and then after this we'll give you the instructions on as to what happens next. Please stay in the vicinity of the auditorium. Thank you. So after a long deliberation, the court has come to an opinion. First, we'll deliver the judgment on the merits. It has been the same decision for both of the cases, so there will be both of the rounds, so there will be one single decision on the merits. And then after this, we will start with the awards, and we will finish as to the winners of the competition. And I would also like to say that the winners of the competition have been decided only by the judges, so the two professors and the two lawyers. We did not take part in that decision. So as to the decision on the merits, the Supreme Court partially reverses and partially affirms the decision of the appellate court. We reverse the appeals decision as to the penalties of the accreditation system and the 14th Amendment. However, we affirm the decision as to the First Amendment decision of the appeals court. And now I will hand it to Jade, the president of ELSA IE, to give the awards.
I was really trying to put all of these in like a good order. It did not work. Okay, so I want to just start off by saying I'm very, very happy with all of you guys' performance. You guys did absolutely phenomenal tonight. And that is very much reflected in what we're going to tell you guys now. So I'm going to go through the first half of the awards, and genuinely this has been a very hard decision. But once I call your name, okay, some of them will be like for teams, some of them will be for individuals. If it's for the team, one of you can come up and claim the certificate. If it's the individual. And if I say your name wrong, I am very sorry. So our first award for tonight is for most creative, the most creative approach to the trial for the 2024 Autumn Trial Competition. And this will go to Manuela Altes. Do you want to hand them out? Congratulations. Yes. The second award that we'll be awarding tonight is for the best opening statement. And this was genuinely, I think, pretty unanimous. And it is my absolute pleasure to award this to Niccolò Milanesi. Next up, we have the best appeal brief. So this was from our previous round of the MLMTC. And this we will award to Hunter Glass's team. And now our competition this year would not have been possible at all without the volunteers, without our amazing jurors. And all of you were a phenomenal help, and I'm extremely thankful for every single one of you. And so we're going to award both a Best Segovia juror and a Best Madrid juror. For Segovia, we are awarding this to Sophia Ratliff. However, from my understanding, Sophia is not with us tonight, so if Martina, do you want to come and pick this up in her name and then get it to her in Segovia? Thank you, dear. And then we're going to do the same for our counterpart here in Madrid. It is my absolute pleasure to award this to Liza Amasova. Okie dokie. A couple more awards here that I'll be presenting tonight. For our Best Witness, this one is going to be one of the names that I'm going to mess up, and I'm very sorry. Anne Saguste MacArthur. If someone wants to pick up her the certificate in her name, though. And now it is an absolute honor to be able to award this next one. This one is the Mitchell L. McLean Trial Award, and this one is for displaying integrity, professionalism throughout the competition, and it's in honor of the late Judge Mitchell L. McLean. And so this one obviously has a special significance, and it is my absolute honor to be able to grant this one to Alexandra.
Okay, now then we are gonna switch the roles. Go ahead. And first we will go with the award for the Best Supreme Court Brief, and this will go to the team of Lorenzo Rosanilla. The next one is the Best Overall Attorney Award for achieving the best performance as an attorney throughout the 2024 Autumn Trial Competition. And this one goes to Rafael Aviles. We would also like to make an honorable mention award, and the honorable mention goes to Lorenzo. And now for the yes, the moment that everyone was waiting for. And we will start with the announcing of the second place. And the second place goes to the team of Fiona. And now the no, we'll just announce. The first place would go to the team of Lillian. I would also like to say that every single person of every team that have come to the final round has a certificate. We would ask you to come here and collect it later after we finish and adjourn the court. And I would ask the panel of the judges to now give a couple of comments on the performance of the teams, whatever you would like to focus on.
Yeah, well, first of all, congratulations to you all. I was again very impressed by the previous students that I met at the appeal argument, and today by the new ones. It's been a great pleasure listening to you all. and yeah, you guys are amazing. Yes, one comment, a side comment about a specific thing that I believe it's important for you to know, which is something to improve and something to keep in mind, not only for the US Supreme Court, but for your life when you are speaking to someone which is very honorable, maybe a professor or maybe a parent or maybe, I don't know, something important, a policeman, whatever. It doesn't matter. But it's not like in the movies that we see trial courts. This is the Supreme Court, and it's very different like trial courts or appeal courts. So you have to be extremely respectful, control your manners, control your tone, control your rhythm of your voice. Don't give assessments of the questions, whether you like it or not. But it's been my personal feeling every time that you were assessing, for example, our questions, maybe not saying, what does have to do with what I'm saying right now, for example, but maybe with your eyebrows, right? So not even that, control your tone and answer in a very, very polite way, saying you're right, or whatever, or always very extremely humble, sorry. I wish you sometime or at some point of your life go to the US Supreme Court and you can remember that. But if not, for any other scenarios where you speak to people that are in higher positions on a negotiation, for example, or when you are asking for a permit of someone. But congratulations again, you are amazing, and I will remember this day with me. Thank you. Thank you.
So on my part, I would like also to congratulate everybody for being here. I think that this was a rewarding experience, not only for the oralists, but for everybody who participated in the process. I usually say to my students, if you feel that my oral exams, they are hard, you need to stand before a judge, you need to stand, in an interview, you need to stand before a client and try to argue your case, why they should hire you, why you should win this case. Overall, I was impressed by your level. However, I want to stress that knowledge is not something that it is confined, within the strict lines of a document. So in order to be a good lawyer, it requires to have general knowledge, to understand in general the case. I do remember when we had the Obamacare. Obamacare was a healthcare law passed by Barack Obama. There was a trial before the Supreme Court. And the Supreme Court judge asked the attorney who was defending the Obamacare, can the government impose on people to buy broccoli? So the question sometimes is not about what is the law, it is about what is your sense, about what is proper or not. And for that reason, you need to have general knowledge to understand the purpose of the law and put it within the context of our society. So legal knowledge is important, but on the top of that, we need general knowledge. With that said, I enjoyed this process, and thank you very much.
Yeah, I wanted to congratulate every one of you for being here, for reaching the final. It's not easy being on the other side. This is my first time being on this side. It's also different to what I expected, to what it feels like. But yeah, I just wanted to congratulate you, and I wanted to touch upon the briefs. I was very happy with the briefs. They were very concise. They were clear. I mean, it's not always easy. We're talking about the First Amendment. It's easy to become too philosophical, to go into arguments that don't hold up, especially when we're grilling you. So yeah, I wanted to congratulate you on that. And yeah, that's it. Thank you, guys.
So congratulations to you all, because it was clear that every single one of you put a lot of work into this, and you all did an outstanding job. I don't know if it's true or not, but I heard that some of you are in your second year of law school, and it's very impressive, because when I was in my second year of law school, I was nowhere, I wasn't even close to where you guys are right now, because you showed the highest of levels today. So congratulations to you all. And just a bit of feedback, like Professor Victor said, when you address a court, you have to be very, very polite, because judges, even if we are not sure sometimes, are people as well, and they like to feel respected. So make sure that next time you address the court in a polite way. Thank you very much.
Thank you very much. And on that note, I would like to thank everyone who have contributed and participated in the fall edition of the Mitchell and McLean trial, and the Supreme Court and the edition for this year is now adjourned. Thank you.